The cards speak. Justice listens. Welcome to the unseen. Truth doesn't hide forever, not from the eyes that see. Spirits stir, clues awaken. Let the seeing begin. Behind every crime, a shadow speaks. I'm Lady Zelda. Welcome to Seeing Crime. Hello to you all. We finally made it. Welcome to the House of Zelda. Today is Friday the 13th. What a lucky day we have. I love it. And thank you all for being here. It is an emotional day already. And I'm watching because Beverly Canoni is going to be giving her jury instructions very, very soon. So we will put this, we're going to watch it together. We're here now. So thank you so much for being here. Thank you for True Oracle being here as well. Hello to everyone who is watching in True Oracle. Hello, Mrs. Marie. Hello, to our mods, AD, and to Jerry. Thank you for taking time out of your day to be here. And this is really something. I got to tell you, I listened to the openings. I teared up when AJ came on there. But then bring on Hank. Pinocchio, Hanky Spanky. Pardon me, I just had a ham sandwich for lunch. So not really, but I had my gravy that I made yesterday. It was just absolutely wonderful. But then Hank came on here. I want to point out some I can't even talk because this guy gets me crazy. The contrast between AJ, Attorney Alan Jackson, and this farce. I mean, this sham. I mean, this faux, you get it, of Attorney General, ADA, Special Prosecutor Hank Brennan. Here's the difference. Here's the contrast. Ready? AJ gets up there and says, hello, welcome. I want to thank you for your hard work. He addressed the jury because the jury is in the house. That's just the way it is. The jury is there. Hank gets up. And what does Hank do? He was 46 years old and he needed help. Who are we talking about? What? There was no addressing the jury we are on day 33, and now we will begin after Judge Beverly, why do I keep saying that, is going to be giving jury instructions. And that's going to be about an hour. And then she's going to release them. And I keep watching, my darlings. I keep watching. So we're not going to miss the jury instructions. And then they may only have a couple of hours. But you know what? Hey, look, I have psychic calls that last 10 minutes. And you would be amazed at what we get accomplished in 10 minutes. So the moment that this jury hits the jury room, I'm going to tell you, it is going to be amazing. And you know what I kept doing? I kept doing this.
Sit down, demon.
The whole time Hank was on there. I mean, Friday the 13th, it's usually a very good day for me. It has been so far. I've gotten a lot done. Welcome to the mountains. You see my mountains in the background. Welcome, my little ghost in the glass, Poe, and the 4 little kitty witches. And of course, everything here. I've got a cup of coffee in the background. I was waiting for you to come in, and I'm a two-fisted drinker. This is from Mrs. Marie from True Oracle. Maybe we can get her to give us some limited editions of these tumblers. I love them so much. And then this, if you're watching Mid-Tennessee Paranormal, look how adorable this is. They sent this. I think I was a winner in one of their contests, but I went out with them a long time ago. Wonderful group. They are on Facebook. I think they're on YouTube as well. So you can go and watch them. I'm sorry, on the Book of Faces. I know. So today, if you could do me a favor, please hit that like button, subscribe, do all those YouTubey things that they like. And I'm going to tell you, I'm so glad that you're here. I really am. I really do believe that this jury sees through this crazy curtain of deceit that this Commonwealth has brought forward. Seriously, I think this is going to happen on Monday. I really think it's going to happen on Monday. I think Karen's going to have a good weekend. It's going to be a good Father's Day. Mr. Reed deserves this. And oh my. So here we are. We're here for the duration. And if you can stand it, I'm going to be talking until 5:30. And then I'm going to go to work on the psychic line. So if anybody wants to come over there and say hello, we have rates for first-time callers. You can go over there and see my profile, my bio. And first-time callers, I'm going to tell you something. You can get 10 minutes for less than a cup of coffee with Starbucks. Certainly less than a combo at your local drive-thru. And you get to talk to me for 10 minutes. And if you call me, all you have to say is, Zelda, look, I'm in your community. This is what I want to know. Because when someone calls the psychic line, and they get overwhelmed, write down your questions before you call. And then you can take notes as we read, because that is the best way to do it. And then you're going to get precise answers. That's exactly how to do it. Hugs to Scotland. Hello, we have Scotland in the house. We have Ireland in the house. I think I saw South Africa just a bit ago. Australia, welcome around the world. This is definitely the shot that's been heard around the world. Bless you for being here, and thank you so much for coming in. Oh, jury instructions. Let me see. Okay, she's coming in, everyone. Let me share this with you. I'll back up so we don't miss anything. How's that? Give me a second. Let me bring her in. Thanks for letting me know. Thanks for letting me know. Here we go. She's just starting, so we're going to go ahead and let me unmute this.
Guilty. That is not enough.
Let me see. I'm going to back it up, my darlings. Here we are. We're going to watch her come in. So we'll behind a little bit, and there she is. It's muted right now. They'll be unmuting. Let me take this banner off. And again, thank you so much for being here. You should be hearing something. Don't know if they're going to unmute. They may not be ready yet. We're behind just a minute or two. So there we go.
Yes,
I'm going to be quiet so you can hear.
Some space here, please.
Take your time, Jerry. Thank you so much for being here.
Hold 1 second.
Hey, Paul.
Contact coming to you. This means, my darlings, this is it. The message is coming. The cards don't lie. Hank does. The cards don't. I did see where, hi, Cat Lady, my darling. Thanks for being here. I did see where she denied the defense motion for transparency. Here we go again.
All right, jurors, going to give you the instructions now in the law. But first, I want to thank you for serving on this jury and for being so attentive. You'll soon deliberate for the purpose of reaching a verdict, but before you do that, it's my responsibility to give you the instructions concerning the law. These instructions are divided into 3 parts. The first part, general instructions that are provided in every criminal
3
case.
pots.
The second part, specific instructions concerning the crimes alleged in this case. And third, guidelines for your deliberations. Please listen carefully to all of the instructions. Do not ignore any instruction or give any special attention to any other instruction. To make sure that I give you the instructions accurately, I will read them to you. You'll also get a written copy so that you may refer to it in the jury room during deliberations. I will try to make sure that my oral instructions match the written instructions. If there is any difference between what I say aloud and what the written instructions say, please follow what I say aloud. You must take the law as I give it to you. You may not quarrel with it. You can't do that regardless of any opinion you may have as to what you think the law ought to be. Lawyers or witnesses may suggest something about the law.
We know
That's
what
not
happened.
necessarily the law. That's because it's my responsibility as the judge and mine alone to instruct you what the law is. I'll now turn to part 1 of these instructions, which are general instructions that apply to all criminal cases. As I've explained to you at the beginning of the trial, there is a fundamental rule that applies to all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Ms. Reed is presumed innocent of the charges in this case. That means you must consider Ms. Reed to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at this trial that Ms. Reed committed the crimes charged. I'll explain what I mean by reasonable doubt in a moment. Ms. Reed does not have to do anything to convince you that she is innocent. She does not have to explain anything. She does not have to testify, call, or question witnesses, or provide any evidence at all, because you must presume she is innocent. Instead, it is up to the Commonwealth to prove the charges against Ms. Reed beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all the evidence carefully and fairly, if you have a reasonable doubt about Ms. Reed's guilt in a particular charge, then your verdict must be not guilty on that charge. You may find Ms. Reed guilty of a charge only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent unless and until he or she is proved guilty, and that the burden of proof is on the Commonwealth. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. How do you decide whether the Commonwealth has proven that each element of an indictment is true beyond a reasonable doubt? Let's talk about the roles we all have. First, the function of the jury. You are the most important people in this room. It all begins and ends with your function. You will determine the facts in this case, and that is your job and yours alone. You are the sole and exclusive judges of the facts. If there are any conflicts in the testimony, it is your job to resolve those conflicts if you can do so. Once you determine the facts, it is your duty to apply those facts to the law as I explain it to you, and to determine whether the Commonwealth has proven its case beyond a reasonable doubt. You must decide the facts solely and entirely on the evidence as you have seen, heard in this courtroom, and on nothing else. No prejudice, no bias, no fear, no favor. You must not be swayed by personal likes or dislikes. Your deliberations are no place for emotion, sympathy, passion, or prejudice. The Commonwealth and Karen Reed have a right to have the case judged by fair and impartial jurors. All parties who come before the court stand as equals before you. Therefore, your verdicts must be based on the law as I'm giving it to you, and on the evidence and the facts that you find, and nothing else. You cannot allow yourselves to be influenced by any personal feelings you may have about the nature of the crimes with which Ms. Reed has been charged or the consequences of your verdict. Just the cool, reflective, and impartial sifting of the evidence so that here in this courtroom, justice may be done. Your focus is on the evidence. I am the judge of the law. My job is to teach you the law that you must follow in the case.
Judge.
However, I have no opinion about how you should decide this case.
You're not teaching anything.
You should not consider anything I have said or done during this trial as reflecting any opinion by me about how you should decide this case. If you believe I have an opinion about the facts of this case, you must disregard it. You must decide this case based solely on your evaluation of the evidence.
For members, there are free Karen Reed
The arguments of the
emojis
lawyers
in
are not evidence. They are not
the chat.
witnesses. If a lawyer during argument
They are
made a
not
mistake
guilty.
in summarizing the evidence or argued something not supported by the evidence, you must disregard it. It is the jury's collective memory of the evidence that controls the matter. Lawyers' objections are a proper part of the court procedure and are not part of the evidence. So don't hold it against the lawyers or their client if they made objections, motions, or other requests.
Oh, we
They're
will.
simply doing their job during the trial. There
Hank
was
never did his
testimony at
job.
trial that the lawyers interviewed witnesses when preparing for the trial. You may not draw any unfavorable inferences solely from that fact. There is nothing improper about conducting such interviews. On the contrary, the lawyers are obliged to prepare their case as thoroughly as possible and may interview witnesses. The verdict must be based only on the evidence and the jury's collective reasoning applied to the evidence in a fair and impartial manner. The extent to which you believe or disbelieve a witness or what an exhibit purports to show, and the importance to give any testimony or other evidence is entirely up to your own good judgment. The evidence consists of the testimony of the witnesses and the exhibits that were introduced in this trial. You will have those exhibits with you in the deliberation room. In addition, as you heard during the trial, the prosecution and defendant agreed that certain things are true. Therefore, you must accept those things as true. There are some things you have heard about that have not been introduced into evidence, such as previous testimony of witnesses, police reports, autopsy and accident reconstruction reports, and perhaps other reports. You may naturally wonder why neither side has introduced any of them into evidence. The answer is that under our rules of evidence, such reports usually may not be admitted, although the parties may refer to them for certain limited purposes while questioning witnesses. So you should not hold it against any party that you do not have them, and neither should you speculate on what they may or may not contain. Similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try to guess what may have been removed from there. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I made, the lawyer's opening and closing statements and any comments they made, are not evidence. If the lawyers or I made any comments during the trial, those comments are not evidence, and you must base your verdict only upon the evidence. In an interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witness, that is, their answers to the questions and the exhibits, are evidence. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. It is important to remind you folks that the verdict cannot be based on emotional reaction or sympathy for any person or side of this case. Certain of the testimony and exhibits may have provoked an emotional reaction in all of us. You may feel sympathy for the family of Mr. O'Keefe, and you may feel sympathy for the defendant as she sits here in the courtroom. But
She's been
your job is to
railroaded in the
decide the
courtroom.
case without bias, fear, sympathy, or favor, to view the evidence with a certain clinical detachment, and to decide the case based solely on the evidence and the application of the law. I have allowed you folks to take notes during the trial if you chose, and you may refer to those notes during your deliberations. But remember, they are not evidence or a substitute for the evidence and your recollection. They are for your personal use. Please do not share them with the other jurors. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Keep an open mind until then. For each indictment, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Your decision as to each charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. When all 12 jurors agree on the verdict for a particular indictment, the foreperson should check off that verdict and then sign and date the slip in ink. For each charge, if you all agree that the Commonwealth has proved every element of the charge beyond a reasonable doubt, then you should find Ms. Reed guilty of that charge. On the other hand, if you all agree that the Commonwealth did not prove one or more elements of a particular charge beyond a reasonable doubt, then your verdict must be not guilty on that charge. You'll remember that we took a view in this case. It seems like a very long time ago, but we took a view in this case. The purpose of the view was to help you better understand the evidence that you heard during the trial and to help you appreciate the locations and their surroundings. Your responsibility in the view was to see the places, observe them carefully, and remember what you saw. The view is part of this case. You may use and consider the observations that you made while on the view in your deliberations in reaching a verdict. The same is true about the demonstration we saw from the witness stand. The demonstration was done simply to help you understand the evidence, and you may consider it in your deliberations. It is the jury's job to earnestly seek the truth of the matter. In doing that, the jury must decide questions of credibility and reliability. The jury must decide how truthful or reliable or convincing any part of the evidence is. You should evaluate the testimony of a police officer in the same way you would evaluate anyone else's testimony. You must not automatically believe or disbelieve a witness just because the person is a police officer. In deciding questions of credibility and reliability, you may rely on your common sense and reasoning powers and your life experiences. Consider a witness's testimony in the context of all the other evidence, not in isolation. You may consider the demeanor, candor, and appearance of the witness in testifying. Who was the witness? What relationship did they have to the case, to the other witnesses or parties? Did the witness have any bias, reason, or motive to give false or shaded testimony? If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the witnesses and the assessment of the evidence presented. Is the witness someone likely to give an honest and impartial account? Consider not just whether the witness was honest, but also whether the witness's testimony was accurate and reliable or honestly mistaken. A prior statement by a witness, if inconsistent with his or her trial testimony in any way, may be considered on the witness's credibility and reliability, and only for this purpose. Also, if there has been a suggestion that a witness recently contrived their testimony, you may take into account any earlier statement the witness made which was consistent with their present testimony. The prior statement is relevant only as to the witness's credibility and reliability, and only for this purpose. You have heard some evidence suggesting that the Commonwealth did not conduct certain scientific tests or otherwise follow standard procedure during the police investigation. This is a factor you may consider in evaluating the evidence presented in this case. With respect to this factor, you should consider 3 questions. First, whether the omitted test or other actions were standard procedure or steps that would otherwise normally be taken under the circumstances. Second, whether the omitted tests or actions could reasonably have been expected to lead to significant evidence of the defendant's guilt or innocence. And third, whether the evidence provides a reasonable and adequate explanation for the omission of the test or other actions. If you find that any omissions in the investigation were significant and not adequately explained, you may consider whether the omissions tend to affect the quality, reliability, or credibility of the evidence presented by the Commonwealth. All of these considerations involve factual determinations that are entirely up to you. And you are free to give this matter whatever weight, if any, you deem appropriate based on all the circumstances. During the trial, I gave you some instructions on how you were to consider some of the evidence you heard, and importantly, how you are not to consider the evidence. I'm going to summarize those limiting instructions here. Ms. Reed is not charged with committing any crime other than the charges contained in the indictments. You've heard evidence about interactions that Ms. Reed may have had with Mr. O'Keefe in Aruba and others in Aruba. The evidence was admitted solely for your consideration as evidence of the nature of the defendant's relationship with Mr. O'Keefe and whether it goes to her knowledge or intent or motive on January 29, 2022. You may not consider the evidence as proof that she has a criminal personality or bad character. You may not take the defendant's prior acts as a substitute for proof that the defendant committed the crimes charged here, or to conclude that if she committed the acts in Aruba, she must have committed the offenses with which she is charged here. You can only use the evidence for the limited purpose of how it goes to the defendant's state of mind, motive, and the nature of her relationship with John O'Keefe. Before you consider any electronic communication in your deliberations, you must first find that it is more likely true than not that the persons who authored the electronic communications were in fact John O'Keefe, Ms. Reed, Michael Proctor, Brian Higgins, or others alleged to have authored or created them. If you do not find it is more likely true than not that the persons alleged to have authored or transmitted or created the communications were the persons alleged to have done so, then you may not consider the electronic communication in deciding the case. Photographs have been entered into evidence, and in some instances, those photographs will be inside an envelope when they go back to you to the deliberation room. The photographs may be graphic and unpleasant. As I told you when you first saw them, your verdict must not in any way be influenced by the fact that these photographs may be graphic or unpleasant. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy. Consider a photograph only as it may show a medical condition, the nature of the injuries, or the details of the incident itself. You heard evidence of statements made by John O'Keefe. These statements were admitted only for a limited purpose of establishing John O'Keefe's state of mind. You are not to consider this testimony as proof that the defendant has bad character or propensity to commit crimes. The testimony of witnesses recounting conversations with Mr. O'Keefe or messages the defendant's phone received from him can only be used as they go to the defendant's motive or intent on January 29th, and only if you find that Ms. Reed was aware of Mr. O'Keefe's state of mind at the time of the crime and would be likely to respond to it. There need not be direct evidence that the defendant learned of Mr. O'Keefe's state of mind, so long as you can reasonably infer from the evidence that she did learn of it. Now, you have heard testimony about statements allegedly made by Ms. Reed. Before you may consider any such statement, you're going to have to make a preliminary determination whether it can be considered as evidence or not, and for what purpose it may be used. You may not consider any such statement in your deliberations for the truth of any such statement unless, from all of the evidence in the case, the Commonwealth has proven beyond a reasonable doubt that the defendant made the statement that she's alleged to have made and that she made it voluntarily, freely, and rationally. In determining whether or not any statement made by the defendant was voluntary, you may consider all of the surrounding circumstances. You may consider any evidence you have heard about the defendant's physical and mental condition, her intelligence, age, education, and experience. Your decision does not turn on any one factor. You must consider the totality of the circumstances. Some testimony came from witnesses who saw or heard something. Some witnesses also told you about opinions or conclusions they reached based on some special training or experience. But special training or experience does not necessarily make the witness's testimony any more believable or important than any other evidence. So you should consider the same questions about witnesses' testimony that I mentioned earlier, including any bias or motive these opinioned witnesses may have had to testify in a certain way. You may also consider the witness's level of experience and training and whether they base their opinions on the facts that you find to be true. There were hypothetical questions asked of some of the witnesses. You may give whatever weight you deem appropriate to the opinion based on the hypothetical, but only if, after careful consideration, you find that all the facts in the hypothetical were true. Remember that witnesses, even those with special training or experience, do not decide cases. Juries do. It is up to you whether to accept or reject, in whole or in part, any opinion or conclusion that a witness offered during the trial. You have the same powers with respect to the exhibits that you do with respect to the witnesses. Look them over and decide the weight, that is the value, that they deserve to receive in helping you resolve the case as you make your ultimate judgment about whether the Commonwealth has proved its case beyond a reasonable doubt. You do not have to believe something simply because it's written on a piece of paper or appears in a photograph. You are not, of course, required to disbelieve it because it appears there. You decide whether to believe what an exhibit purports to show and how much weight, if any, to give the exhibit. Certain charts and summaries not admitted into evidence have been shown to you as testimonial aids intended to summarize, clarify, simplify evidence, or to help explain the contents of records, documents, computer data, or other evidence introduced in the case. Charts and summaries are not new evidence, and you should give them only such weight as you think the underlying evidence deserves. So you've heard me talk about sources of evidence in this case. Those are the tools that you have to decide the case. Now, with that evidence in mind, what can you do with it? As jurors, you may bring to bear all your knowledge and experience. You don't check your common sense at the door to the jury room. Just the reverse. I instruct you to use your common sense. Give the evidence a reasonable and fair construction in the light of your common knowledge and experience. In determining the facts in this case, you may draw reasonable inferences from the evidence that you believe because you're entitled to rely upon both direct and indirect or circumstantial evidence. Direct evidence is evidence of what a witness claims to have seen or heard or touched or somehow perceived with their own senses. Indirect or circumstantial evidence exists where a witness does not testify directly to the fact that is sought to be proven, but you are provided with evidence of other facts and then asked to draw reasonable inferences from them about the fact that sought to be proved. Such inferences may be considered with all of the other evidence in reaching your verdict. Indirect or circumstantial evidence alone is sufficient to establish guilt beyond a reasonable doubt. Now, what do I mean by an inference? An inference is a logical deduction or conclusion that you may, but are not required to draw from evidence that you have accepted as believable. Inferences are little steps in reasoning, steps in which you take some known information, apply your experience in life to it, and then draw a conclusion. Sometimes you can draw more than one inference. You have to decide which inferences are reasonable and decide which seem more reasonable to you. Remember, when you're dealing with inferences, you never have to infer anything. You may, but do not have to draw inferences whatsoever. An inference drawn from indirect or circumstantial evidence need not be necessary or inescapable, but any inference which you do draw must be reasonable and possible. It must be logical. It must be a natural one, which is not too remote in the ordinary course of events. You may not guess. You may not speculate. You may not engage in surmise. You should not pile inference upon inference until the pile gets so high that it tips over logically, or that the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure that they're still reasonable. Further, when the evidence tends to equally give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all of the evidence and the reasonable inferences that you have drawn, taken together, prove that she is guilty beyond a reasonable doubt. Let me give you an example of an inference. Suppose that the issue you must decide is whether the U.S. Postal Service delivered the mail today. If you go home and someone in your household hands you the mail and states that they observed the letter carrier deliver the mail and retrieved it from the mailbox, this would be direct evidence that the U.S. Postal Service delivered the mail. The witness perceived the events with his or her own senses and told you what he or she observed. The issue you would have to decide is whether that witness was credible. On the other hand, if you go home from court and find mail in the mailbox, you may infer that it was delivered by the U.S. Postal Service today. You draw this reasonable inference based on the following known facts. The mailbox was emptied yesterday. You know that the mail is delivered by the U.S. Postal Service Monday through Saturday. The letters in the box are postmarked. You have exactly the same power in this case, not the power to speculate or to guess, but the power to draw reasonable inferences warranted by the evidence in the fashion I've just described.
If I start snoring, forgive me.
You may have noticed that Ms. Reed did not testify at this trial. Defendant has an absolute right not to testify since the entire burden of proof in this case is on the Commonwealth to prove that the defendant is guilty. It is not up to the defendant to prove that she is innocent. The fact that Ms. Reed did not testify has nothing to do with the question of whether she is guilty or not guilty. You are not to draw any adverse inference against the defendant because she did not testify. You're not to consider it in any way or even discuss it in your deliberations. You must determine whether the Commonwealth has proved its case against the defendant based solely on the testimony of the witnesses and the exhibits. Now that completes the first part of my instructions.
My heck.
Now I'm going to turn to the elements of the charges against Ms. Reed. The Commonwealth has alleged that on January 29, 2022, Ms. Reed did assault and beat John O'Keefe with the intent to murder him, and by such assault and battery did kill and murder John O'Keefe. So in that indictment, Ms. Reed is charged with second-degree murder. Now I just want to tell you that our Supreme Judicial Court has promulgated jury instructions on homicide charges that I have to read verbatim. So I want to make sure to do that right. So murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. 1, the defendant caused the death of John O'Keefe. 2, the defendant intended to kill John O'Keefe or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to Ms. Reed, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of John O'Keefe. A defendant's act is the cause of death where the act, in a natural and continuous sequence, results in death, and without which death would not have occurred. The second element is that the defendant intended to kill John O'Keefe, or intended to cause grievous bodily harm to John O'Keefe, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. As you can see, the second element has 3 sub-elements, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of these 3 prongs beyond a reasonable doubt. The first prong is that the defendant intended to kill John O'Keefe. This means that the defendant consciously and purposefully intended to cause John O'Keefe's death. The second prong is that the defendant intended to cause grievous bodily harm to John O'Keefe. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that she intended to perform the act, you must then determine what the defendant herself actually knew about the relevant circumstances at the time she acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. If you have a reasonable doubt as to whether John O'Keefe's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved that the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. In deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. If the Commonwealth has proven both elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the second indictment is the indictment charging manslaughter while operating a motor vehicle under the influence of liquor. And there are lesser included offenses on this verdict slip as well, and I'll explain those to you as well. In order to prove manslaughter while operating a motor vehicle, the Commonwealth must prove the following 5 elements. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that the defendant operated the vehicle wantonly or recklessly so as to create a high degree of likelihood that substantial harm will result to another. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating a motor vehicle. A person operates a motor vehicle while doing all of the things, the well-known things that drivers do as they travel on a street or highway, and also when doing any act which directly tends to set the vehicle in motion. A person is operating a motor vehicle whenever they are in the vehicle and intentionally manipulate some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the defendant operated a motor vehicle in a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street or road is a public way, you may consider evidence, if any, about whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are buildings along the street, whether it has any crossroads intersecting it, whether it is publicly maintained. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that while operating a motor vehicle, the defendant was under the influence of intoxicating liquor, that is alcohol, and or the percent of alcohol in the defendant's blood was 0.08 or greater. I will now instruct you on both theories. What does it mean to be under the influence of alcohol? It is not illegal to drive after consuming alcohol as long as the operator is not under the influence of alcohol. However, neither does someone have to be drunk to be under the influence of alcohol. A person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected emergencies. The amount of alcohol necessary to do this may vary from person to person. The Commonwealth is not required to prove that the defendant actually drove in an unsafe or erratic manner, but it is required to prove that the defendant's ability to drive safely was diminished by alcohol.
Probably Monday.
You may rely on your experience and common sense about the effects of alcohol. You should consider any believable evidence about the defendant's alleged consumption of alcohol, as well as the defendant's appearance, condition, and behavior. In deciding this theory of
Because
whether the
that's all they
defendant
really
operated a
have.
motor vehicle under the
He
influence
admitted
of alcohol,
to drinking.
you may also consider whether a blood test showed that the defendant had consumed alcohol. However, no matter what the reading is, the blood test is not sufficient by itself to prove that the defendant was under the influence of alcohol. Under the second theory, the Commonwealth must prove beyond a reasonable doubt that at the time of operation, the percent of alcohol in the defendant's blood was 0.08 or greater. The Commonwealth may prove a person's blood alcohol level by a chemical test or analysis of their breath or blood. In deciding whether the Commonwealth has proved the defendant's blood alcohol level beyond a reasonable doubt, you may consider evidence, if any, about whether the test was administered within a reasonable time of operation of the motor vehicle, whether the person who administered the test was properly certified, whether and how the pre-test procedures were followed and employed, whether the testing device was working properly at the time the test was administered, and whether the test was administered properly. You may also consider any other evidence pertaining to the test or the test results. The fourth element the Commonwealth must prove beyond a reasonable doubt is that the defendant operated the vehicle wantonly or recklessly. A person drives recklessly when they ignore the fact that their manner of driving is very likely to result in death or serious injury to someone, or they are indifferent to whether someone is killed or seriously injured. It is not enough for the Commonwealth to prove that the defendant acted negligently, that is, acted in a way that a reasonably careful person would not. It must be shown that the defendant's actions went beyond mere negligence and amounted to recklessness. The defendant was reckless if she knew or should have known that such actions would pose a grave danger of death or serious injury to others, but chose, nevertheless, to run the risk and go ahead. Whenever I refer to the defendant's state of mind or her intent, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite state of mind or intent even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Here, the defendant must have intended her acts in the sense that they were not accidental. But it is not necessary that the defendant intended or foresaw the consequences of those acts, as long as a reasonable person would know that they were so dangerous that death or serious injury would probably result. As such, the Commonwealth does not need to prove that the defendant intended to kill John O'Keefe. Rather, this is in that category of cases where public safety requires each driver, once they know what the situation is, to determine and to adhere to an objective standard of behavior. In determining whether the defendant drove recklessly, you should take into account all the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and control her vehicle. The condition of the defendant's vehicle, what kind of road it was and who else was on the road, what the time of day, the weather, and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The fifth element that the Commonwealth must prove beyond a reasonable doubt is that the defendant, by her actions, caused the death of John O'Keefe. The defendant caused the death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act is a natural and continuous sequence, results in death, and without which death would not have occurred. If the Commonwealth has proven all five elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Now, the lesser offense of manslaughter while operating a motor vehicle under the influence of liquor includes the lesser offense of involuntary manslaughter. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with that lesser included offense. The Commonwealth may prove the lesser included offense of involuntary manslaughter, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence. So I'm going to define involuntary manslaughter for you. To prove that the defendant is guilty of involuntary manslaughter because of wanton or reckless conduct, the Commonwealth must prove the following elements beyond a reasonable doubt. First, that the defendant caused John O'Keefe's death. Second, that the defendant intended the conduct that caused John O'Keefe's death. And third, the defendant's conduct was wanton or reckless. I will now discuss each element in detail. The first element is that the defendant caused the death of John O'Keefe. Remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. A defendant's act is the cause of death where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element is that the defendant intended the conduct that caused the death. The Commonwealth is not required to prove that the defendant intended to cause the death. You may consider any credible evidence that the defendant was affected by her consumption of alcohol. The third element is that the defendant's conduct was wanton or reckless. Wanton or reckless conduct is conduct that creates a high degree of likelihood that substantial harm will result to another. It is conduct involving grave risk of harm to another that a person undertakes with indifference or disregard of the consequences of such conduct. Whether conduct is wanton or reckless depends either on what the defendant knew or how a reasonable person would have acted knowing what the defendant knew. If the defendant realized the grave risk created by her conduct, her subsequent act amounts to wanton or reckless conduct, whether or not a reasonable person would have realized the risk of great danger. Even if the defendant herself did not realize the grave risk of harm to another, The act would constitute wanton or reckless conduct if a reasonable person, knowing what the defendant knew, would have realized the act posed a risk of grave danger to another. It is not enough for the Commonwealth to prove the defendant acted negligently, that is, in a manner that a reasonably careful person would not have acted. The Commonwealth must prove that the defendant's actions went beyond negligence and amounted to wanton or reckless conduct, as I have defined that term. In deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another, you may consider any credible evidence that the defendant was affected by her consumption of alcohol. A defendant may have the requisite knowledge even if she consumed alcohol, but you may consider such evidence in determining whether the Commonwealth has proved this element. Now, the offense of manslaughter while operating a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI, and negligence. As a matter of law, the indictment that is before you that charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor also charges her with the lesser included offense. With that lesser included offense, the Commonwealth may prove the lesser included charge of motor vehicle homicide, even if it fails to prove the greater charge of manslaughter while operating a motor vehicle under the influence of liquor. You may find the defendant guilty of motor vehicle homicide only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide. On the verdict slip, that just means you start from the top and you work your way down. In order to prove the defendant guilty of motor vehicle homicide, the Commonwealth must prove the following 5 elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated the motor vehicle upon a public way or in a place in which the public has the right of access. Third, that while the defendant was operating the motor vehicle, she was under the influence of intoxicating liquor and or the percent of alcohol in the defendant's blood was 0.08 or greater. Fourth, that while operating a motor vehicle, the defendant did so in a negligent manner so that the lives or safety of the public might be endangered. Fifth, that by such operation of the motor vehicle, the defendant caused the death of John O'Keefe. Elements 1, 2, 3, and 5 are the same as manslaughter while under the influence of alcohol, as previously instructed a few moments ago. The difference between manslaughter while operating under the influence and motor vehicle homicide is the 4th element, so I'll focus on that. To prove the 4th element of motor vehicle homicide, the Commonwealth must prove beyond a reasonable doubt that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when she fails to use due care, that is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances, or by not doing something that a reasonable person would do. The defendant acted negligently if she drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that she could have avoided by driving more carefully. The defendant's intent does not matter, so do not consider it in determining whether or not the defendant was negligent. There is no requirement that the Commonwealth show that the defendant intended to act negligently or unlawfully. Under our laws, public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, what the defendant may or not have intended to result from her actions is irrelevant. The issue is whether or not she drove as a reasonable person would have under the circumstances. In determining whether the defendant drove negligently in a manner that might have endangered the lives or safety of other people, you should take into account evidence, if any, about the defendant's rate of speed and manner of operation, the defendant's physical condition and how well she could see and control her vehicle, the condition of the defendant's vehicle, the kind of a road it was and who else was on the road, the time of day, the weather, and the road conditions, what any other vehicles or pedestrians were doing, and any other factors, including the defendant's consumption of alcohol, that you think are relevant. The offense of manslaughter while operating under a motor vehicle under the influence of liquor also includes the lesser offense of motor vehicle homicide, felony OUI liquor, and the lesser offense, I'm sorry, hold on. And the lesser included offense of operating under the influence. As a matter of law, the indictment that is before you, which charges the defendant with manslaughter while operating a motor vehicle under the influence of liquor, also charges her with these lesser included offenses. So the Commonwealth may prove the lesser included charge of operating under the influence, even if it fails to prove the greater charges of manslaughter while operating a motor vehicle under the influence of liquor and motor vehicle homicide. You may find the defendant guilty of operating under the influence only if you are not convinced beyond a reasonable doubt that the defendant is guilty of manslaughter, and you are not convinced beyond a reasonable doubt that the defendant is guilty of motor vehicle homicide, but are convinced that the defendant is guilty beyond a reasonable doubt of operating under the influence. To prove the defendant guilty of operating under the influence, the Commonwealth must prove elements 1, 2, and 3 that I instructed you on motor vehicle homicide while OUI.
There's a ham sandwich
So
emoji for
the
members.
third indictment is leaving the scene of an accident resulting in death. In order to prove the defendant guilty of leaving the scene of an accident resulting in death, the Commonwealth must prove 6 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that she operated a motor vehicle on a public way or in a place which the public has a right of access. Third, that the defendant knowingly collided with John O'Keefe. Fourth, that the collision caused injury to John O'Keefe, resulting in his death. Fifth, that after causing such injury, the defendant failed to stop and provide name, home address, and registration number of the motor vehicle. And sixth, that the defendant failed to do so for the purpose of avoiding prosecution or apprehension. Jurors, I've already instructed on the first and second elements. The other 4 elements should be given their plain meaning, and the parties agree that I do not need to define these any further, correct? Okay, thank you.
Yeah, it's a lesser included.
All right. As a general rule, you're permitted but not required to infer that a person who intentionally uses a dangerous weapon on another person intends to kill that person or cause him grievous bodily harm, or intends to do an act which, in the circumstances known to him or her, a reasonable person would know creates a plain and strong likelihood that death would result. An item that is normally used for innocent purposes can become a dangerous weapon if it is used in a dangerous or potentially dangerous fashion. The law considers an item, in this case a motor vehicle, to be used in a dangerous fashion if it is used in a way that it reasonably appears to be capable of causing serious injury or death to another person. In deciding whether an item was used as a dangerous weapon, you may consider the circumstances surrounding the alleged crime, the nature, size, and shape of the item, and the manner in which it was handled or controlled. That completes my second part of the instructions. I'm now going to turn to the third and final part, which is shorter.
Thank you.
In order for a jury to return a verdict, that is to reach a decision in a criminal case, the law provides that there may only be 12 persons on the deliberating jury, and you will note that there are 18 of you. To avoid the need for a new trial if one or more jurors becomes ill or is to be excused for some good reason, we customarily impanel extra jurors at the beginning of a trial, as we did in this case. Because of the anticipated and now actual length of this trial, we impaneled more jurors than are commonly impaneled. However, when you begin your deliberations, the law in Massachusetts is that only 12 jurors can deliberate. Therefore, at the conclusion of my instructions, Mr. McDermott will reduce your number to 12 on a random basis. The jurors not selected to serve in the jury will become the alternate jurors. If you are selected as an alternate juror, please do not feel that your efforts in this case have been wasted, because as I've indicated, it's important that we have extra jurors in case of an emergency. If we did not impanel extra jurors and a juror became ill, or for some other reason had to be excused, we would have to try the whole case all over again with the new jury. In the event that a juror has to be excused once the jury starts deliberating, then an alternate juror will be chosen to take that juror's position, and the jury will be required to start deliberations from the beginning. Therefore, it's important that the alternates not discuss the case with anyone else, including each other. For if an alternate becomes a member of the jury for deliberations, the alternate's views should be his or her own and not be influenced by anyone else. Different states and jurisdictions use different means to select a foreperson of the jury. In some jurisdictions, the jurors select their own person. In Massachusetts, the judge is responsible for selecting the foreperson. A foreperson of a jury has been described as the first among equals. He or she is responsible for organizing the deliberations, communicating with the court if necessary during deliberations, and presenting the verdict following your deliberations. The foreperson has no greater say or vote in the jury's deliberations. However, in that sense, the juror is equal with all other jurors. I am going to ask the juror seated in seat number 1, your juror number 5, sir, would you agree to be foreperson in this case? I'm going to ask you if you would be foreperson in this case. Thank you. I always appreciate it when people say yes before I tell you what's involved, but thank you very much. All right. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree. So, all right, so I skipped the line. And when you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in this case, as well as the verdict slips that you'll be using in returning your verdict. So the foreperson will be given the verdict slip setting forth the charges against the defendant. 12 jurors must agree before you have a decision to any specific charge. That means that to find the defendant guilty, all 12 must agree. To find the defendant not guilty, all 12 must agree. You should consider each indictment individually and continue deliberating until you've reached a final verdict. You should not begin deliberating until all 12 jurors are together in the jury room and should cease deliberating if any one juror is not present in the jury room. It is important that you not communicate with anyone outside the jury room about the deliberations or about anything concerning this case. Further, I remind you that no juror is better qualified to determine the truth of the facts in this case, to dispute or to deliberate on a verdict solely because of education, background, or experience. The parties and I have chosen each of you as fair and impartial jurors, and your voices have equal weight. To reach a unanimous verdict, each juror must agree. Jurors have a duty to consult with one another and to deliberate with a view to reaching an agreement, if it can be done without violence to individual judgment. At the same time, each juror must decide the case for himself or herself, but only after impartially considering the evidence with his or her fellow jurors. Don't hesitate to re-examine your views and change your opinion if convinced it is wrong. But no juror should surrender an honest conviction to the opinion of fellow jurors simply for the purpose of reaching a verdict. Although how you conduct your deliberations is up to you, I urge you not to begin by conducting an immediate straw vote. Rather, I encourage you not to take any votes before you've had completed a careful and thorough collective view of all the evidence. At this point, I want to remind you of an important issue that I raised with you at the beginning of this trial. I told you that our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. I also pointed out that we all have our own built-in expectations and assumptions, even if we are not conscientiously aware of them. And I talked about some of the ways we can try to deal with them. First, slow down. Do not rush to a decision. Hasty decisions are the most likely to reflect stereotypes or hidden biases. Take time to consider all the evidence. Second, as you start to draw conclusions, consider what evidence, if any, supports the conclusions you are drawing and whether any evidence casts doubt on those conclusions. Double check whether you are actually using unsupported assumptions instead of the evidence. Third, As you think about the people involved in this case, consider them as individuals rather than as members of a particular group. Fourth, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? Fifth, listen to your fellow jurors. They may have different points of view. If so, they may help you determine whether you are focusing on the facts or making assumptions, perhaps based on stereotypes. Of course, your fellow jurors could be influenced by their own unstated assumptions, so don't be shy or hesitant to speak up. You should participate actively, particularly if you think the other jurors are overlooking or undervaluing evidence you find important. In fact, when you explain your thoughts out loud to other jurors, you are also helping yourself to focus on the evidence instead of assumptions. If you use these strategies, then you will do your part to reach a decision that is as fair as humanly possible, and that is your responsibility as jurors. Now, during the course of your deliberations, you might have a question concerning the law in this case. Perhaps I said something you did not understand. If you have any questions, please feel free to bring them to my attention by writing a note dated and signed by the foreperson and sending it to me by way of the court officers. I'm not suggesting for a minute that you have to have questions, but if you do, that's the process. Because your role as the jury is to determine the facts in this case, I cannot answer any questions you have concerning the facts of the case. I have no role in this case when it comes to deciding what the facts are. Neither is it possible for me to provide you with a transcript of the testimony. If you send a question to me, I'll respond after consulting with the lawyers. Please do not ask a court officer or anyone else to answer any questions concerning anything material to the case. Generally, we will not answer a question or take a verdict from 1 o'clock till 2 o'clock, but I think you've all waited so long to get this case, I think we can change that. But the court staff needs a luncheon break. You'll have lunch brought into you, and you can decide whether or not you want to stop your deliberations during lunch or continue and deliberate. At the end of the day, if you're still deliberating, I'll send in a note asking if you want to continue deliberating or break for the day and return the next morning. Don't tell anyone, including me, how the jury stands numerically or otherwise on the questions before you until such time as you've reached a unanimous verdict. You are going to notice shortly that the court officers are going to take an oath, and you will hear from that they too, as well as all other persons, are forbidden to communicate in any way or manner with any member of this jury on any subject touching on the merits of this case. Remember that the decision of the jury must be unanimous, and the foreperson should be certain that each member of the jury is in complete agreement with the verdict on each indictment. After the final vote of the jury, the foreperson should check the appropriate boxes as to each charge, then sign and date the verdict forms and notify the court officer when you've reached a unanimous verdict. You will then be brought back into the courtroom where the foreperson will deliver the verdicts. This will be the last time I'm going to see counsel at sidebar, but I'm required to see counsel at sidebar.
Okay, so we are behind a little bit. I'll go ahead and speed this up so we can get caught up, okay? So give me a second here. There we have the fan. There we don't have the fan. I was starting to sit here and yawn. I got a lot to tell you, so we'll just wait until they are discharged and then we'll go. They go until 5:30 today. So, and at 5:30, I have to close my stream because I start work on the psychic line at 6. So don't forget, if you want to talk to me, if you got questions, write them down. If you are a first-time caller, you can get 10 minutes for less than a cup of coffee at Starbucks. So just have your questions ready. There's a significance, if I can talk, to that Pardon me. We'll talk about it as soon as they're done. Let's hope and pray this is the last time we see her until after the jury comes back and acquits Karen. And then no more Hoff days. Here we go.
Judge, the first thing is counsel this morning and yesterday looked at exhibits, and I believe that we were pretty close. We had one exhibit that needed to be dealt with. Ms. Little, what number is that one again? 150? 155, and I'll let Ms. Little take it from there.
Yes, there's just one page, Your Honor. I believe, and my memory is not perfect, but I believe that if we were to have this redacted, subject to the same redactions from last trial, I think there's just one line here that needs to be redacted.
Okay, is the Commonwealth in agreement with that one line?
No objection. I believe it was redacted last time, so if the defense
Okay.
wants to make that redaction, we can go into evidence.
Great.
I'll see that Sharpie and maybe I can take care of it.
I think we probably have one here you
I
can
have one.
have.
I definitely have one somewhere.
All right.
That's number one. And number two is, can counsel look at the verdicts and just tell me if verdict slips and just tell me if they're okay with it? Thanks.
You'll see that it's not what you provided me yesterday, Mr. Kennedy.
When they're done, we'll talk about some things.
Sworn in first. Counsel, you can keep doing that. Mr. Rose, can you raise your right hand? Do you solemnly swear that you will keep that jury in some separate but convenient place
Oh, well, they
until they
just
agree that
announced
you not
his
suffer
name.
any
Way to
person
go,
speak to them
Jim.
or speak to them yourselves,
Mr.
nor ask them if they
Rose.
agree, nor suffer them to disperse them, they are charged their verdict, except by further order of the court, so help you God. Simply because you weren't in the room. Thank you.
He just announced that juror's name.
Is the Commonwealth content with the verdict slip?
I thought they were, because he said, do you swear that you'll keep the jury in line? So if it was a court officer, great. If not, then let's hope it was not a juror.
Your Honor, I understand that you've rejected our proposed verdict slip.
So everybody else can sit down. Mr. Yannetti can stand.
Thank you. I understand that you've rejected our proposed verdict slip. Our concern with this verdict slip is that there are 4 options for, actually more than that, 7 options for guilty verdicts, 1 option for not guilty. And we're concerned that this is too confusing for the jury. So we are asking that there be not guilty options for each of the charges, including the offense charged and each one of the lesser included offenses.
Okay, thank you.
We really ran into the same issue last time. I think what complicates it is the fact that there are 2 theories for 2 of the lesser included.
Do you suggest that doesn't accurately reflect the law?
It does reflect the law. I'm not saying that. I'm saying that it makes things very confusing, and that's why we believe that it cries out for some not guilty option, given the amount of options for convictions on this verdict slip. So
Okay.
we would again ask the court to adopt our proposed verdict slip.
So your proposed verdict slip did not cite any case law. Do you have any case law that supports that proposition, Mr. Yannetti? I have not found any. I've looked.
There's not a lot of case law out there in this verdict slip either.
Other than that has never been proven, has never been found to be inaccurate.
Not yet.
Okay.
And I mean that
So
with all respect.
that's fine. So your rights are reserved. Does that help you?
Right, well, all we can do is object, Judge, and you make
Okay.
you make the decision.
Okay.
Judge, the last couple.
If you find authority for that, let me know.
We'll do.
Okay.
The last couple of things, judges, that we were provided with a clean
Laptop?
computer laptop. Thanks. We were, with a clean laptop. Defense counsel had a chance to, or at least defense had a chance to look at it, and I think that's fine. But
All right. So we'll send that in with the exhibits. I need to go edit my charge to fix all the typos.
and then the final thing is I provided counsel with the exhibit list that we had, and it was satisfactory for both sides.
Great.
So, thank
All
you.
right. Thank you.
All rise for the court, please.
Well, she's a real stinker, isn't she? A real breath of fresh air. Let me see what's going on in the Twitterverse right now. See if there's any new things or anything going on today other than what we already know. And then we're going to talk about some things. So there we go. Let me see here. Okay, I don't see anything too earth-shattering right now. Lots of lawyer commentary on the what is happening there. So we'll just give that a minute and we'll bring it back if somebody comes back. Okay, my darlings. Here's what I want you to know. When we ask spiritually for help, we're going to get it. So we should expect it. So by saying we want a not guilty verdict, oh, well, this is happening and that's happening. It may be. But when we ask for divine help and spiritual help, it's going to be sent. Now, one thing I've got some questions here. I want to go back and answer those. And I think Messy Jessie, I think somebody explained, I think it was Kim, explained the ham sandwich thing. If you need to know that any further, then let me know. Born a Hawkeye says uncivil, that is Kurt. With uncivil laws reported that she has 6 overturned convictions. She does. But from my understanding, from talking to my lawyer sources, if a conviction gets overturned, the Commonwealth, unless it's with prejudice, the Commonwealth can come back and charge her again. The really worrisome thing is that if something went completely wrong and she was found guilty on one of these murder charges, they would not let her go for sentencing. They will take her to they'll take her to jail where she will await her sentencing, or if they appeal, which I'm sure they would appeal. But my darlings, an appeal can take a very long time, months, and maybe even years. So we don't even want to go there. We're not going to go there. I do not believe there will be a guilty verdict. All right. So the next thing we have from AK and Cat Lady is the seat number 5 is significant. What is the meaning of number 5? Well, let me tell you what the number 5 is. Okay. Number 5 is very significant in biblical numerics. It means grace. It means grace. Now, in other things, my darlings, in numerology, standard numerology, Vedic numerology, it's all about change. It's all about movement. It's all about, get it, freedom. It's all about, and sometimes unpredictability, because if judge or somebody else picked juror number 5 because they felt they could predict what this juror could do, say, want, etc., and maybe that juror doesn't want to do it, or maybe, there's a lot of things that can happen. It can also, the number 5 can also ensure that this verdict not just get rubber stamped, that they just go back to the jury room and say, oh, boom, guilty, bye. Number 5 can guard against that sort of thing. Through a tarot lens, let me show you this. I pulled it out for you. The number 5, let me see if I can get that up there, is the Hierophant. Now, the number 5 in the Hierophant, this is all about structure, moral duty, tradition versus questioning authority. It can mean a dedication into what needs to happen. And I'm going to tell you, I think this is a big hint for us that the juror will actually feel a sacred responsibility to do it right, to get it right. Whether that means following the law or that means standing up for something that this juror actually feels right. As in, Karen, no, sorry, no ma'am, no ma'am, no ma'am. So sorry. I have a little girl here who just turned on the light. Okay. Let me start that over. It's a hint of whether this juror can actually feel a sacred responsibility to get it right, or whether that means that they're going to follow a structured law or use their gut instinct and know exactly the hanky-panky that was here, that was stupidly done. It also can mean if you're in the position of number 5, typically this is a front seat row, in the front row, center seat, excuse me. And it really depends on the structure of the courtroom. Symbolically, this could mean that we're talking some type of balance. I'm going to tell you, I really think that this juror, the reason that they were picked is because, there's so many things, pardon me. And if you see her, she has a skin problem, psoriasis. So she's not being beat. She's a little girl, but I hide her here because everybody has a problem with looking at her. And, Bless her little heart. We put stuff on it. So anyway, she just is, this little gal just is, she's feral and she's a digger. She's a tuaka, she's a digger. So anyway, there we go. I believe that this is, I believe this is Scooby, and she is blind in one eye and getting ready to go blind in another. So sometimes she just, sometimes you just need your mama. That's her. Thank you, my darling. But you know how sometimes people are just ugly. So thank you. Thank you. Apparently the alternates are 2, 6, 7, 8, 13, and 17. Very good information, Anne. Thank you for sharing that. My little schnauzer baby. I'm going to tell you, I think a lot has to do with, we have heat here. We have fleas here that almost seem unstoppable. And I give them flea treatments all the time. So, and if you could hear her purring, I don't know if you can hear her or not. But anyway, she's a girl. She's a girl. 6 was pro Karen. Okay. Well, we don't know. Number 5 may be 2. After hearing all of this today, I mean, I'm just, excuse me, ma'am. No. Purring in my ears. Yeah. This is Shooby-Doo. I call her, she's Scooby, but she's Shooby-Doo. So I have Shaggy and Scooby were in the same letter. So, yeah, she's my precious girl. She sure is. She's saying hi. Okay, calm down. You're going to have to get down. Just calm down. She will in a minute. So anyway, my darlings. Okay, my. Number 8 is an infinite number. I'm going to tell you what I think. Thank you so much, you guys, for the kitty love. Thank you. I'm going to tell you what I really believe. Let's back up a little bit to closing arguments. We heard all about we heard all about, all right, ma'am. Hank, what did he focus on? He did not focus on any of the evidence because he knew he was in the toilet. He knew that instinctively. He knew that. And now, as it goes, what did he say? Well, I'll tell you what he was saying. Everything is all about, oh, hi, Bianca. Welcome, my darling. Welcome. Come on in, subscribe, like. You're going to love this. You're going to love it here. So here's the things. He focused on her drinking. Did you notice that? All right, ma'am, you're going to have to get down. This is a disturbance. It's disturbing your mama. And so, hi, Melissa. Welcome. Hi there. Welcome. Come on in. You're more than welcome. Welcome to the House of Zelda. Well, if you didn't listen to Hanky, it was a very true contrast of what was said by, okay, ma'am. Thank you and goodbye. Goodbye now. Sometimes I can't take too much love. No, you're not. Okay. If you just calm down, you'll be okay. There we go. Welcome to the House of Zelda, where we have, this is the stream of Scooby's Shooby-Doo. Anyway, my darlings, Hank was focused on the drinking, the OUI, DUI, whatever it is. And I just heard a cough. And there's nobody. And it's like right here. And there's no one. Well, anyway, he lied. He was trying to lead them in a different direction. It was so different. It was a yawn. But he wanted to, he started out strong for 5 minutes. This man was 46 years old. He was a pillar in the community. He helped everyone. He was strong. He was a good man. From there, it was just downhill. Ma'am. So the horrible thing about this is that he focused on her drinking. They don't have an accident report. None was ever written. And she was never charged with any OUI. There's no anything, nothing. And yet they can give her a lesser included. That's the only thing that concerns me. But here's the thing. If you find a couple weeks, hi, my darling. Thank you so much. Hi, Zelda. Well, I'll tell you what, I'm feeling very good about things and very optimistic. But I am concerned that we're going to hit another mistrial. And it's only because the jury instructions, and it's only because the confusion to the jury about was she drunk? Well, we all know that she was drinking and driving. And the fact that everybody else was drunk and drinking and driving has no merit in the case. But I think that is the biggest thing right now. I think that is the biggest thing. Hi, Cheryl. He focused on things that were not fact. That's right. He argued in the car. He doesn't. I had to shut him off. Yeah. I had literally had to go to the kitchen. Patty, if there was a mistrial, do you think the prosecution would go again? Without a doubt. They'll keep trying her and trying her and trying her. Without a doubt, they'll go for her again. Without a doubt. Without a doubt. There will not be, and we'll be here for another year, because that's how long. It'll be more of the same. It'll be more of the same. And I think right now we have to keep very positive, because I believe that, I'm going to tell you what, the opening for AJ was masterful. How was it masterful? He went through a timeline, an outline that was easy to understand, easy to work with, easy to talk about. And then boom, all of a sudden you get Hank up there who's here. Let's talk about this. Let's talk about that. I heard that he actually was talking to Mrs. O'Keefe. And of course, that's okay, before this all started. And can you hear the conversation? The only thing that keeps me positive is that in the wee hours of the morning, and it was storming. It just now let up from storming. It's still raining. But in the whole thing, and I'm going to tell you, people are saying within 2 hours. It's 3:00 right now. They will come back by 5:30. I hope y'all are right. I'm saying Monday. Hank ran over his time. He went past an hour and a half. He went past an hour and a half. Thank you so much for your generosity, my darling. Thank you. Had to come here for some sanity, Zelda. Well, I think you're going to get it. I think we're in a good place. I really do. But I also want to be realistic about this. I think the foreman is a good pick, number 5. I think that's good. I want a 2-hour, 27-minute deliberation time, poetic justice. Absolutely. I want the same as well. Oh my gosh, would that not be wonderful? I agree. I agree. Well, and you know what? The stats are that prove that on Friday afternoon, pardon me, you see me here? That's from this girl. Because when cats are happy, they shed. And she's like a little pig pen right now. Have you ever seen pig pen on Charlie Brown? Where he just, the dirt just flies. She's not dirty, but there's still some fur. So anyway, I feel that it probably will be Monday, because I think usually what happens is juries, anytime I was on jury duty, we would go into the jury room, reintroduce ourselves. We would kind of go around the room. We would kind of go, this, that, the other thing. We would talk about surface things, and then we would start getting into it. The fact that it's before the weekend and the fact that they don't want to be here, I think is very helpful. And also, I think the facts, the way that AJ laid them out, and he addressed all the facts. There were absolutely none in Hank's closing. He just kept harping on she was drinking. There's no proof that she backed up and hit him. And they're still pushing on that little bit about, so she backed up, she hit him, he pirouetted, she wiped him out, and then he got up, unlocked his phone, all of this silly stuff. And I'm going to tell you, what is the bet that the majority of the jurors have iPhones and they know better, right? They know better. Hello to each and every one of you coming in. Stop. It's enough now. It's enough. Stop. Go see peace. So yeah, there we go. Okay. AD is on jury count. 28 minutes they have been out. Hi, honey. Welcome. Oh, look how pretty you are. I love that. Hi there. Hi there. Welcome to the house of Zelda. Welcome, welcome. Where, this is my boss today. His closing was supposition. Yes. Yeah. Zelda, can we kick out a mistrial by pulling a card and just going with 100% not guilty? Yeah, let me get her calmer, because that's just too hard to try to manipulate the cards, but I will do that. I think we've got time. That's enough, Angel. Ouch. Uh-oh. Somebody's this close to getting in some trouble, because I don't tolerate biting. Biting is a no-no. All right, let me read some of your questions and concerns. She said she was going to stop them. A quick verdict in this case, I'd say not guilty. There's a lot to talk about if they're going for guilty verdict to be quick. Yes. But I'm going to tell you, I think if they came back and said not guilty, I wonder if she would say, are you sure? Are you sure? Do you want to go back again? And I think that would be definitely unconstitutional. But knowing Bev, when is she worried about that? Okay, so don't they say juries have verdicts on Fridays? Yeah, they do. A very high percentage of a jury having a verdict, no ma'am, on Friday. Very high. Can you believe Queen B, I was going to say quarterback. Queen B Bev still has the same verdict sheet. Yeah. AJ is a star. Absolutely. They will be looking at Proctor's text. They are actually sending are you okay? They are actually sending a laptop back to the jury room with all the evidence. So anything that went into evidence can be retrieved on the laptop. If there's anything more, then they have to ask the attorneys and the judge. So that is a good thing. She makes the same deliberation mistake at the last trial on the verdict slip. Yeah. Yeah. Laststock explained he was not able to function after that hit on the head, right? And there's death within 15 minutes because the brain stem swells, or the brain swells into the brain stem, into the spinal cord, I think is really how that, I'm not medical. That's pretty bad. Annie, hi, darling Zelda. I was a paralegal for 25 years. Welcome. And I have never seen a court run like this. I was a paralegal for a lawyer in the United States Navy a few hundred years ago. And that's when I thought I wanted to go to law school. I was a paralegal at many law offices, mainly around Charleston, South Carolina, and on base at the Navy base in Charleston, South Carolina. And the big thing is I've seen it all. And especially what I'm doing now and working with all kinds of, in the past, law enforcement agents, lawyers, prosecutors, judges that were horrible, everything else. I've never seen anything like this in my life. And this is frightening. I'm more scared of this group. Pardon me. I'm more scared of this kind of thing than I am the paranormal. Do you have any breakdown for any of the other remaining jurors? Okay. Well, but you know what? It's okay that if they don't want to take notes, it's okay if they don't want to take notes, because in this particular case, I probably would not. I probably would not take notes, because you know what? If you hear something that is out of bounds, you're going to retain it. You're going to retain it. That is for sure. Absolutely. Jack, my wife and I are having ham sandwiches for lunch. Good for you. Does that make us biased advocates for the defense? I think it does, Jack. Guilty as charged, and happily so. Enjoy your ham sandwiches. I have something on my screen. Let me wipe it off here. It's driving me crazy. I was thinking I had something on my face. Okay. So that's funny. Guilty as charged, Jack, and my best to your wife. Oh, wow. Miss Zelda, where is my son went to? Oh, wow. My husband at that time was a lieutenant commander in the Navy and was an engineer on a frigate that was out of the base of South Carolina. And I was a paralegal for a lawyer who now practices in Michigan. Wonderful. So anyway, he's wonderful. Thank you. You know what? I wanted to do something a little whimsical today. I wasn't going to wear these. And I thought, oh, it's the first time I've worn them. So they're a little different, but it's okay. I get it. I get it. Okay. So, yeah, very bad. Under 35% survival rate, and survival would be a vegetative state. Well, here's what I think the jurors are going to get. The fact that they put 2 and 2 together, from especially Dr. LaPosada. She brought it home. She's our girl. She brought it home. Saying, well, you're dead in 15 minutes. And then the call from Jennifer McCabe. I'm so glad that AJ brought this up. But I have 2 things I want to tell you during my meditation this morning. And there's a comment here I want to star for just a second. During my early meditation, I saw Karen walk over and hug Mr. O'Keefe. And that's before we were even in the courtroom this morning. I mean, it was early. It was like 4 something this morning. And when I saw that, I thought, okay, that's good news. That's good. Ma'am, Ouch, that is my skin. Whoa. Ooh, fingernails. Oh, okay. We're going to fight a little, I see. Sorry about that, everyone. She gets excited. No. All right. Sorry. That wears me out, but she took a little hunk out of me. Oh, my goodness. So I think that's what brought it home. If I were a juror in this case, I would not want to take notes only to a certain degree. I would want to be aware and watching because you can retain the bad stuff. And on all the ARCA stuff where it got really, really techie, I wouldn't be writing down that anyway because the reality is I probably couldn't comprehend it when I took my notes back to the jury room anyway. I would probably look at it and say, oh, what was that formula again? Because I don't have a strong math background. But I still feel that we're okay. I still feel that we're okay on this. Now, I'm going to tell you this. I love this. Honey 2800, you are our people. The dead are not scary. The living are to be feared. That's absolutely something that I know. The only thing, I'm going to tell you the thing about entities, ghosts, and all that other stuff. And of course, there's evil, but it's my experience, there's not a demon around every corner. So there's always, but the scary thing is that you don't know, like these audible voices that I hear every now and then, and you sometimes hear them when I'm streaming, and like something popping up out of the cosmic unknown. It's more startling. It's more startling, but scary. Can the dead put you in jail for the rest of your life? Certainly not. I'll take that any day. Why does she choose I don't know. I think that's just the way Massachusetts runs it. I'm not sure about that. Aiden Turtleboy said the juror didn't take notes, was pretty chill, and he didn't worry about him. Yeah, I don't think there's any reason to worry about him. I think the vibe that I'm getting is common sense. Just common sense. There you go. It was a young male who was seated closest to the witness stand who had to move. Give me just a second. I'm going to go off stream. Just 2 seconds, and I'll be right back. Okay, back again. Thank you so much. Okay. They could have nominated a note taker, but I don't. Maybe. I wish Bev didn't have to read those directions D1111 says, or instructions to all the jurors, knowing some would be able to deliberate. It would, my thing of it is, you go in there and you think, this is so confusing. Pardon me, ma'am. No. And I would think, this is so confusing. And it's, to me, I think it's very confusing. I was in tears during AJ's because it just brought it all home. It was real. It was real. I'm with V. I don't mind somebody that doesn't take notes. No, I don't think, I think it's a matter of preference. And I think that's it. I wish that the jury, Amy said, would send a note that says we're all not guilty boxes. Yeah, where are all the not guilty boxes? I think I certainly would. How do you prove someone is not guilty? Comparatively so. So there we go. Annie, I want to know why Bev chose that male. Well, he could have been a little older. He could have looked a little settled. I mean, it could have been one of many people. It could have been, I mean, I don't know. It, I'm going to say it could be just divine. It just could be a divine intervention. And that's what we've been hoping for. That's what I'm going to believe, is that it's divine intervention. But I have another question for you. Yesterday, after closing, whenever it was, no, we didn't have closing. Yesterday, anyway, today, yesterday, whatever day. What day is it? Hello? You know what my first thought was? I wonder if Dr. Rentschler went back and called his contact with the feds and said, you got to do something. This girl is being railroaded. Have you seen this case? She is not guilty. If she gets strung up for murder, you got to do something. I don't know what, but I just had that feeling. And I've also heard in many other cases that a very good, hi there, my darling Karen. Hi. I've also heard in many other cases that two of the witnesses called the Commonwealth and said, if you want us to rebut, we're not coming back. We don't have anything to say. You're on your own, pal. And they can refuse after they have been like released of their duties, the sequestration or whatever that thing is that they say that you're not supposed to talk to anybody. Well, as soon as they're released, they don't have to do anything anymore. I do hope that Rentschler was incredible. I believe that I believe he was. It was him. I think it was Dr. LaPosada, him, not in any order because they are all perfect. Dr. Rentschler, Dr. LaPosada, Sergeant Barrows, Dr. Wolf. I'm probably forgetting somebody. Sequestered. Thank you, Karen. I can't say it. Hello. Yeah. But I just wonder. You know what? Resisting arrest, I believe so too. Oh, yes. And Lucky Bob, thank you so much. Lucky Ann, yes. Absolutely. Elizabeth Argon, no one has my ideas about the non-movement of the phone after he was killed, right? I'm going to tell you what I think. I think that Higgy went to the Canton Police Department, in my opinion. Don't notice facts. I wonder if Higgy went to the Canton Police Department, got a Faraday bag, because they know, and went back over to 34 Fairview. The fact, I'm going to tell you something, okay? Look what you do to me. The fact that AJ mentioned Higgy several times, Jennifer McCabe, Brian Albert, but especially Higgy, there's something up. There's something up. And bless Karen's heart, I saw where, I mean, I'm sure you noticed too, Karen, she looked bad. She did not look like she slept. I'm sure it was the same as the last trial when she said this morning, and is this going to be the last time I hug my family? Because if they come back with guilty, they'll take her immediately from the courthouse. That is a reality that she's facing. Imagine being in her shoes. I do not believe that's going to happen. But I do believe that it could be another mistrial. But I also believe, and I have confidence that it can be a not guilty based on how this went. Purple Ninja says all the defense witnesses were amazing. Those experts. Yeah, oh yeah. Karen says Dr. Lapazada nailed it and wiped the floor with Hank and his attempt to bully her. That was epic. Totally epic. I loved it. A dear one. Hi, my dear. Oh, look at that. Oh, a deer, a female deer. The dog bite lady, I'm forgetting her name. I'm tired. Listen, I have not been so, can't pronounce anything, can't think of words, can't think of, mommy's angel. Listen, we all need rest. And I can tell you what, I'm certainly not going to Aruba. Every time they say that, there is that song, Aruba, Jamaica, yeah, comes in mind. Why? Called Lucky. He was the first one they planned on blaming. Truly was lucky. Yeah. Yeah. They did consider that. But she fell in place perfectly. And I'm going to tell you something. What else I feel is the reason that, and I can say this because it's my opinion and I'm not a lawyer, and thank God, but I think one of the reasons that Jennifer McCabe was peering out to her through her window was that this event was beginning or had already happened, and she was on watch to see if Karen was going to come into the house. That's what I feel. That's what I get. What was that about Welcher? He didn't want to come anymore, right? It was Welcher and Shannon who said, you destroyed us. They destroyed themselves, okay? But Hank brought this out because Hank didn't do his due diligence. He didn't do his job. He knew that Shannon's CV was hosed up, going after your master's degree for 17 years, forevermore. I mean, that's a lifetime. This case screams karma. Yes. Yes, a Faraday bag, bent hook, that smartwatch, his phone. Yep. There's something up. Yeah, there's something up because I don't know if you noticed that there was a shift. And the shift is all of a sudden they were going to go gung-ho after the missing witness and for the the missing witness and then the what was it? Third party culprit. And they said, nah, on each one of those. Nah, it's okay. I think they knew that Hank was going to blow it and he was going to be stupid. I think that was it too. Dr. Lapazada's Dr. Lapazada's description of John's injuries and manner of death had me worked up. It did me too. I heard about swelling of the brain, but never knew how it worked, right? And you know what I really liked about Dr. Lapazada? The fact that she broke it down and didn't talk to us like we were dummies. She talked to us in layman terms. She talked to us like we could understand and did not throw these big, I mean, you saw Wenchler. He thought he was the one sitting there all relaxed, arms up on the witness. Even Bev, I think, was upset with him. And I know what it was, is I think somebody told Hank, you better calm yourself down. And I think that's why yesterday we didn't see him at that charging conference. I think that's why we saw Lolly ma'am. There we go. Annie says Karen has lost a lot of weight and she cannot afford to lose any. Right. She needs a rest. I did too, my darling. I did too. You don't feel like that's a possibility, though, do you, Zelda? That it's a guilty? No. No. No, I don't. Just learned Bev's appointed her ringer as jury foreman exactly like last time, which yielded a mistrial. But who did you learn that from? And we don't know. I'm going to say I don't know. I mean, everybody has an opinion. We don't know. That's the scary part. 100% latte. Hi. I love that. 100% was a Faraday bag that moved the phone to under John's body, right? Because if they took him out through the bulkhead and around the back of the house and through the gate and dumped him on the front lawn, why would they do that? Well, probably because they knew the neighbors had a Ring camera, even though they got rid of the footage. Cat Lady, if they come back as guilty, I think every single one of us being protesting from wherever we are, there will be outrage. If they would come back guilty, I do not see that. The only thing that I think that she's at risk, though, is the lesser included with the OUI. And I think they could overcome that. But see, there's no accident report. And see, that's why they think they could overcome that. And I'm sure that they would appeal that. So, there was no collision. All else is a moot point. That's right. She didn't hit him. In my honest opinion, fight in the garage, someone threw the glass at Jay. He fell backwards, hit his head on something, then, oh crap, covered it up. From my understanding, when I had the remote viewing, he showed me where he went to the basement. And he was holding a glass. And when he went to take a drink, somebody smacked him with the glass. But he also said that he was jumped because as he was going down the steps, someone pushed him. Two people behind him, one behind him, two people in front of him. He was pushed, and it started from there. We have to think of the basement, because why else would they change out the flooring? Because Brian Albert knows about these types of stains. You can't get rid of them, ever, ever. And most likely why they sold the house, because there was just too much there that needed to be cleaned up and redirected. I mean, we don't know. The feds could have the carpet. They're not going to tell any of us. Could they have taken him to the garage? Yeah. They could have taken him right out through the breezeway and right out to the garage and laid him there, because he talked to me, and you can hear that in that Christmas Eve video that I made. I think it was Christmas Eve or New Year's Eve, one of them. But it was all about him laying in a cold, dark place. They put him in a cold, dark place. But there's another little something I don't want to glaze over. And that is Matt McCabe. One thing that I don't know if you remember hearing this today. You go have your little ham sandwich, my darling purple ninja. We'll be here when you get back. There you go. So the one thing that AJ said today was Jennifer McCabe, and you didn't meet her husband, Matt McCabe. Oh, that told me right there that Matt McCabe was involved. And I've always thought so because of the energy. And think about this. It could be this thing of, Matt McCabe gets in the middle of this and he goes and tells Jennifer, you've got to hold everybody back. You got to do something. And this is why I feel that Jennifer was the one, Mrs. Kravitz, looking out the window and looking to see, not to see if Karen left, but to see if she was going to come in. Because if Karen came in the house within that whatever time period that was, what is that? 10 minutes, 8 minutes, 12 minutes. I'm going to tell you, my darlings, you can lose your life in 0.7 of a second. That's all it takes. And for all of this, John had not lost his life, but I think that they kept him somewhat going. Think about all this. It's scary to think that these people know something, and don't tell me they don't know anything, because they know it, and I will get in their face. No, I won't. No, I won't. But you feel like it. You feel like it. It's frightening to think of what these people have done. I think Karen says, I think the Dream Team will be instrumental in the Fed's case against the NCDA's office, CPD, the MSP. Yep, I do too. I think that they probably know. They probably got word through David Yannetti. Kim says 7 females, 5 males are deliberating. Good. Those females are likely to say, Bilbo is right on the other side of my microphone, laying on my desk snoring. So he's not groaning. He's snoring. It's nap time. They're sleepy except for this thing. It's my little girl. She finally calmed down now. So that's where that is. But yeah, I'm sure. How long has the jury been out now? They went out, I think, an hour. Something like that. Is it that long? Has it been that long? Maybe. They're having their little lunchy. They should have lunch. But I'm going to tell you something else about jurors. They don't get paid much. So the first thing they think of is, well, we'll get lunch. It's very hard for a jury to come back without getting their lunch. I've seen jurors, though, coming back at 10, 11 o'clock at night. But they're only going to go until 5:30 today. So there we go. Yes, that's my Bilbo, him snoring. He's laying, him and Riley are laying right here on my desk. They feel like I cannot, I'm the one sequestered. Okay, let me see. 58 minutes. Thank you so much, my darlings. 58 minutes. Probably more so than that now. It's okay, my darling. No worries. I will not accept anything less than a not guilty, no matter what the Judge Hefferly said. I agree. And Rage Crochet Nanny, look at those little sweet peas that you've got. Mrs. Kravitz, Abner, come look. Right? Abner! Come look! Abner! There's a giraffe on the lawn! Right? Those were the days. In my opinion, Rosebud says, I say time served for all the corruption, demons, ruthless people in this case. I say just not guilty, because it's double jeopardy. They not guilty, they can't come after her. But I will say, I hope she has her security around her, because she knows stuff she's not supposed to be knowing. And evidently someone fears her. Think about this. Why? Other than covering up for themselves, they don't want her talking. They don't want her saying anything. They don't want her doubling down on anything because I think they feel she knows more maybe than what she really does. And it could be about Sandra Birchmore, which is a completely different area. Great numbers for girl power. I agree. It was the Golden Girls with Mrs. I'm sorry, not Mrs. Russell, but it was Dr. Russell, Dr. Lapazada, Dr. Scotty Bello, and I forget her friend's name, but you all know who it is because I'm like, hello. So, yes, absolutely. That's what it is. The Alberts got right of John like they did with everything else they do with everything like the dog, the house, the car, the phone. Oh, yeah. Oh, yeah. Just wait. Just wait. Yes, 1 hour. They had a 30-minute lunch earlier, okay? And not guilty. Wouldn't that be cool? Nikki C, Beach Cowgirl. I love that. Wouldn't that not be cool? At 4:44, they announced. I was looking for 3:33, and I've got the fan up, everybody. See, here's where we are right now. Oops, no. There we go. There's where we are right now. So I keep watching. For the jury, I pulled cards. Fool, the Hermit, High Priestess, all upright. Very good. Patty, didn't she say she asked them if they wanted to keep going, she would let them after 5:30? I don't know. But I can tell you this, my darlings. At 5:30, I have to say goodbye to you, but I'm still going to be watching, okay? If I hear or get any inkling and I'm not on a psychic call, I will come back on here live and we will watch the verdict together. Now, she may call them back to say goodbye to them. I think that's how they do it. At 5:30, if they don't have anything. So there we go. I wanted to go out and do my errands this morning, and it has crashed and banged since last night. And it is just now, and it's too late for me to go out and run my errands. So I'm either going to have to do it tomorrow morning or Monday morning before we get started. And it's, I think it's going to be, but it's supposed to be raining. It's raining now, but it has stopped this violent storming and the violent, pardon me, ma'am, during Brennan's closing with my phone in my pocket. Every woman I saw wearing pink, I thanked them for their silent report. Support? I think that's wonderful. I think it's wonderful. I can see that there are other people up there streaming now. I was proudly wearing my Free Karen Reed shirt. I'm wearing mine tomorrow night. Now, I will be going live tomorrow night. Don't miss that at 7 p.m. We're going to stay on track. There we go. I'm going to take 2 hours and 27 minutes. I'll take it too, my darling. Listen, I'm with you. Not guilty of all charges. Very good. Very good. I had to turn off when Hanky spoke. My blood pressure can't handle him. Lol. Yes, Gramir Rain, I get it. When he started to speak and when he came out and said he was 46 and a good man, I thought, oh, here we go. Here we go. Okay. I did not see what suit. Almost an hour per suka. Okay. Almost an hour. I think we're an hour right now. Hi, Trisha. Hi, Lady Zelda, watching from US. On holiday. Well, hi, on holiday, hoping and praying for not guilty. Well, thanks for stopping in while you're on holiday. That's pretty cool. AD says, 5 notebook guy, her science juror, this juror, she thinks Pyre's people are among the alternates. Okay. I heard that there was, hi, Melina. Oh, how pretty you are. I always look at the red lipstick because I have red lipstick envy. New information on Sanderberg Birchmore case. Yes, they found out that Matthew Farwell, who they have arrested for her unaliving, was actually not the father of Sandra's baby per DNA results. Can you imagine? Can you imagine Matthew, how he feels now? Look what he did. That scumbag. Look what he did. Thinking he was going to get out from under it. The joke's on him. And it's not a joke, but it is kind of now. I bet you Sandra is laughing in heaven and going, there you go. Zelda, what would be the best deck to pull from a yes or no with Karen? Several, but we're going to do that now that this little thing is starting to calm down a bit. Bless you over there. Okay, so my granddaughter came in singing, "Give Me Joy in My Heart," when Judge was finishing her instructions. Oh, look at her. How precious. How precious. Oh my goodness. There we go. There is a German Shepherd next to me in a parking lot, barking like crazy, right? Right? I get it. Okay, so started 2:42 Eastern, so 2:27 would be 5:09, okay? We'll take your word for it. That sounds good to me. I'm eating chocolate and I am not a chocolate person. I wish I had some. I was about, listen, after I get done, I'm going to go in and make a sugar-free cheesecake. And it is so delicious. Well, it's not sugar-free. It's very low sugar. Very low sugar. And it's delicious. Foreman is number 1, previously number 5, I guess. Okay. I'm going to try my pendulum. I would try mine, but I don't have enough room. And every time I get it out, these guys see something is moving and they start swatting it. 5:09. Wow. For to come. Yeah. Poor Sandra. Poor Sandra. Oh, yeah. Okay. I think Nan Gallagher was up there too. It is very heartbreaking. That's another one. You have an echo now. It's probably because I moved my thing toward my thing. That's a technical term, isn't it? I moved my thing. You should post. I will post the cheesecake recipe. Hold on a minute. Let me. I've got my mic down, everything down. Okay. Yes, isn't that so? My darlings, we have some things that we're going to be looking into. The Madeline DeSoto case, I started on that one when I was early in the early days of Karen. But Karen just kept taking these weird turns. And I believe there's a court date for that guy. I'm not going to get into it now because I want to read up on it. In July, we're going to visit that. Then there's some other things that are come up, and we're going to visit those too. So believe me, we're going to have a lot to talk about. I'm cleaning and watching and cleaning. Bless you. Well, good. I'm going to tell you what, when this is over, I probably need to take 2 days and just clean my house, because for me, that's therapy. And not that my house is dirty, but let me tell you what I found. And my grandmother used to do this. And I forgot all about it. But my grandmother did not have animals at all. She used to pet the cat, like she'd take the back of her hand and pet like this. My grandpa went to the doctor one time, our family doctor, and said, "Can you tell my granddaughters not to kiss their cats?" Because we had, oh my gosh, we would kiss the cows. We would kiss everything. And he would say, can you tell them not, we're afraid that they're going to get a disease. And he said, oh my gosh, tell them to kiss the cows, tell them to kiss the cats. It's not going to hurt a thing. So there you go. So, but I found the most wonderful thing that I have to share with you. Excuse me here, ma'am. And that is, you know, the shaving cream that men use, the Barbasol, and the red, white, and blue can. It's the foam. If you put a little bit on a cloth and rub that, now test your furniture. Don't do this on anything you don't know. But if you put a little bit on a cloth and you dust, no dust. It repels the dust. And I started doing that again. I did it a long time ago because my grandmother would do it. Ma'am, my grandmother would do it, and no dust. And it works here. This is a very dusty place that we're in. So, yeah. Yes, it is, Bodo Bob. It is a great glass cleaner. And the chrome, you can shine your chrome. I'm one of these. I can't use those really stout cleaners. I love Murphy's oil, soap, that sort of thing. But yeah. Yeah, I'm here for all the home hacks. Thank you for coming in. So dryer sheets do that along with baseboards. Keeps my, oh, really? Okay, I'll have to try that. I don't use dryer sheets, but yeah. Cat lady, my grandmother, who lived until I was 26, that came from Poland when I was born to take care of me, always said cats won't in your sleep. I have too. They spent the night. Well, I know what that is because my grandmother used to do the same thing. They would say that a cat will come and suck the life out of a baby. And I always watched my kids because I had this old cat, bless her heart, we called her Binks. That poor thing was beat up. She had one eye. She'd go out and fight dogs and everything else and come back beat up, but she was just the most loving thing. And after I had my son, I think he was probably 3 months old, she came home one day. I did not even know this, and I couldn't find her. And I heard these noises. And I looked under my son's crib, and she had a litter of kittens under his crib. Okay, Binks, what a girl. So anyway, I always thought that was funny, but that's why. And the reason being that they say that is because if there is, a cat will smell milk on a baby's breath and will either lay on them or something. But yeah, that's a big European thing, huge European. We went through that. I would have to fight my grandmother on, oh, he's going to that cat's going to suck the life out of the baby. So there we are. So dryer sheets I like, but I don't use them. I don't use them in the dryer. Thoughts? Hi, misbehaving in Florida. Look how cute you are. Welcome here. I thought cats take away bad energy. They do. And they are big time in energy they are huge big time in Verdict Watch. Thank you so much, my darlings. We're going to put this up here. They are huge. Cats are big on knowing when energy is around. These guys will tell me when there's orbs. You can see, I'll have to play that for you one day. Or you could see the orbs. Bilbo, maybe I have it handy. Let me check real quick. Let me check. We'll get our minds off of things a little bit because sometimes it just gets a little heavy, right? It just gets a little heavy. Stop, Sister Bison. Okay, let me see here. Okay, I have one here. Maybe let's play it. Let me see here. I think this is the one. It's kind of grainy. But this has got a lot of orbs, and you can hear Bilbo and see him. 1 hour. Here, hold on a minute. 1 hour, 12 minutes, 20 seconds left. I really want that 220, right? I'll take that or 333. 227, 333. All right, so let's take a look at Bilbo and the orbs. Okay. This is in my house.
Zelda. It is Wednesday, December 10th at 10:10 p.m. That is my kitty, Bilbo. He is stressing because something is in the corner. I think you just saw an orb there.
Let me start this over. I don't know if you can hear it, but I'm just narrating. But that is my cat, Bilbo. Now that is as you're looking at this, that is the hallway. And you can see he's looking up in the corner. That is the master bedroom on the left-hand side. On the right-hand side, it's kind of like standing in front of the door where I saw the hand come out. That's the bathroom door. And then down that hall is the second bedroom. So you can see that he's looking up at the light. He would get really upset. Okay, so here we go now.
Zelda. It is Wednesday, December 10th at 10:10 p.m. That is my kitty, Bilbo. He is stressing because something is in the corner. I think you just saw an orb there. You can hear him meowing. What are you? And what are you doing here? That's my furnace running in the background, by the way. Sorry for the shaky hand. Too much coffee today. Let's try to, oh, there was a big orb. Okay, we're getting some activity here. That door in front of Bilbo there is the hallway bathroom. He is looking up in the corner there. That, to the right of that picture, is a bedroom. To the right of the bathroom door, down the hall a little further, is another bedroom. My son is in the bedroom. You may hear him laugh, and I'll mark that if I do hear him, so you don't think it's something else.
So that's pretty much it right there. But there was another one I wish I could find. There were a lot of orbs that were going around. I need to play the necklace video where you can actually hear the growling and stuff going on while I was recording. Maybe we'll play that if we have time. Does anybody want to see? Is kind of it's me narrating. It's about a necklace. It's an antique. It's about 100 years old with a handkerchief. There's a story behind it. So, I mean, it's up to you. If you want to see it, let me know. Put it number 1 in the chat while we're waiting. Put a number 1 in the chat. Or if you want to hear the vampire story, put 1 in the chat if you want to see the necklace, or 2 if you want to hear the vampire story. We can do both. I think we have time. Number 1. Okay, let's see if I can find it here. Let me find it. All right, so here we go. This is just a 4-minute video. Let me see here. Okay, hold on. Okay, my darlings, let me share this with you. Okay, so here we go, my darlings. I'm just kind of trying to keep up with the chat. Let me share this with you. I'm seeing that things are, the fan is still going. So we're just going to be here. We're going to be talking. I'm going to share some stories, and here we go. Here is the necklace video. Oops, hello. Hold on. Here is the necklace video, my darlings. Oh, I can't. Oh, shoot. Let me see if I have it here. All right, let me do this. I'm going to unshare this just for a second, but I'm going to keep that in. And then we'll share this. Here we go, my darlings. This is called the Haunted Necklace. It's okay, my darlings. That's all right. It's all right. We're here. So here we are. There we go. Now let me fix this so you can see this a little bit. And you're going to want to listen. You might want to, if you got earphones on, you're going to want to really maybe turn that up, because growling and everything else. So disclaimer there. So here we are. Hi, everybody. This is Zelda Kelly. And instead of taking some pictures, I thought I would do maybe a little video. We might catch something on here. I had an experience earlier this evening that was different. So if you will give me the honor in watching this, I will show you what I was talking about. There is a couple of items in this bag. I'm unboxing it, or I'm unbagging it. I keep it in this bag just really to keep it dust free. But it is on a black cloth, and I have my pendulum nearby. We'll do a little bit of pendulum work as well. You can see that I'm wearing my trusty yellow glove. I always do this when I touch these types of items. So let's just go ahead and get started. The first item, and these items are pretty old too. They're at least, I'm going to say, I would say 70 years. This is a handkerchief that went along with this, other than me breathing,
with this necklace. And you can see that it's old, it's kind of rotted. And that's why I keep it in that plastic bag. So it's got some, whoever did this, and of course, back in the day, I mean, this had to be in the 30s, 40s, something like that. They always did a lot of crochet work. And if you can see that, whoever did that took a lot of love when they did that. So very aged, very old. And here is the necklace. There we go. Again, my recorder cut off. I would suggest that no one ever wear anyone else's jewelry, clothing. Don't go to stores, thrift stores, antique stores, buy these things without knowing what you're getting and without clearing them. So this is it. And like I said, I really had an event earlier with this. So I'm going to go ahead and box it up, put it away. But I wanted you to see it. They're two really quite beautiful items. That little heart there, I always thought was very pretty and delicate. Anyway, this is the necklace you're supposed to be seeing full body apparitions. I've never tried it, and I'm not going to.
just based on the experiences that I've had with this. So thank you very much again, everyone. Be well. And thank you again. This is Zelda Kelly, and peace to you. It says, during my initial unboxing, I heard taps, breathing, my son calling for me, and he was not, to find out that he did not, and a light turning off by itself. I finally captured these videos to show you. After the events of unboxing and videotaping this reveal, I slept on my living room sofa last night until I had time to do a proper clearing of my room. These items will not be following me when I move. These are really something. So thank you so much for watching that. I appreciate you. There we are. Okay. Let's see. That's why the defense wanted a part of the form. True. Who else is an empath and highly sensitive? It's overwhelming. Yeah, I can't hardly go into antique shops, resale stores. I got this from an estate, like an antique place. I was actually driving down the road and looked at it, and I thought, oh, wow, that's pretty weird. That's pretty funny. I'm going to do this. I went in. I did not know this ring was in here, and it was in a case, and I was just drawn to it immediately. I bought it, but I did not wear it until I brought it home and I put it in a vat of salt for 48 hours, and then I made sure that it was cleared and everything else. So that's where this ring comes from. It is a smoky quartz, I think. So there we go. That's how that worked. But yeah, do not, thank you so much. I don't wear clothing that are, I got to keep checking, that is not appropriate. Like for me, like I don't, Stitch Fix, all that stuff, I don't do it. I just don't do it. I don't do it. Let me see. I want to read something for you. Our dear Maud AD in the chat. I use whatever salt I have handy. I like the Himalayan pink, but if I don't have anything else, I mean, if I have to use table salt, I do it. But I like the Himalayan. But I'm going to read something. They have come back to court. Let me see. I've got it on here now. I've got Boston 25 on. Let me see. Let's get him up here. Okay, we don't have that yet. That was from Melanie. Let me see if I can find something else here. I don't see Melanie's live. Let me check in my history here. Okay, so it looks like, let me get Court TV on here. Then we can see. I don't like Court TV, but we'll take a look. Court TV has a poll up. Give me a second. I'm going to share it with everyone. I have to release this one first. And I'm going to share Court TV. Karen is actually going back into the courtroom. And I'm sorry. I know I could have given birth by the time this came about. Let me see. I think that's what it is. Court TV. Yeah, that's it. Let's see. Here we are. Okay, so it's just going through the commercials right now. Yeah, Melanie is live. It just showed them going back into the courthouse. And as soon as they come back on, the sound comes, or as soon as they come back on in the court, I will put the sound back on. The counter is still going. Okay, so let's see. Verdict watch is 1 hour, 33 minutes and 19 seconds. So we're just waiting right now, my darlings. We're just waiting. Okay, I think it just showed that Karen and team have walked into the courthouse. I think that's really what it was. I think because David Yanetti's has a I think they were probably at lunch and they're just probably there. I'm hoping. Let me check a few other things. Law and Crime are confirming they are coming back in the courtroom, and it may be jury questions. Okay. And that's what I said earlier. I think that they may have a few questions. That's probably what it is. Because they watch them have questions about the jury form. Just watch them. We'll be here, my darling. We'll be here. Well, they're delivering. They're in it already. We know. Said she was going to keeping them until 5:30 today, so we'll see what's going on. Yes, on the jury form question. Yes, there we go. Forms would have been done an hour ago, right? My forms would have done. Turtle Boy said they put the balls in the spiny thing in front of everyone. There you go. Yes. Oh, gosh. This is nerve-wracking, isn't it? Oh, my heck. I'm watching you and Melanie. Okay. She's got the legal commentary on there. And so I don't know. 1 hour, 35 minutes and 57 seconds and counting right now, my darlings. So here we go. All right, we're going to take that down for a second. I can still watch it. Wow. This is nerve-wracking. This is nerve-wracking. Thank you so much. Do what Tina says, please. Like and subscribe. Thank you so much. Yeah, Melanie is with Defense Diaries. So there we go. Now, after, we'll just wait and see. Okay, hold on.
Anything to say to your supporters?
Thank you. I love that.
What do you say to supporters?
Thank you.
Thank you one more time.
So that was just moments ago as Karen Reed returned to the courthouse there in Dedham, Massachusetts, because, of course, we are on verdict watch in that courtroom where a jury is now deliberating the fate of defendant Karen Reed.
And prosecutors have accused the former adjunct professor of striking her boyfriend, John O'Keefe, with her SUV while driving in reverse and then leaving him to die outside a home in Canton, Massachusetts.
Of course, Reed insists that she is innocent and has pleaded not guilty.
We're gonna just shut you down because I can't stand court TV. They are so biased. And I've kept the closed captions on so we can see Karen. She looks beautiful today. She just looks beautiful. I'm going to tell you, I feel terrific, honestly, about things. Let's pull a couple of cards while we're waiting. If I can get this thing right here. Calm down. Please don't. She does. Karen just looks totally beautiful today. Let me check my messages, make sure I'm not missing anything. So when I have to go at 5:30, my darlings, because I do need a minute. Please stop. I do need a minute to stop. Have a little bit of dinner and then go on the line, but I'll be here watching. And if there's an emergency and they come back, I'll be right here. I'll just jump on. So just keep watching, my darlings. Keep watching. Here we go. Yeah, the defense was summoned back. Yep. Here we go. On the bottom of the deck, it's the Knight of Pentacles. That is basically hurry up and wait card. It's an action card. It's just like you've been summoned down the courthouse. Now just sit there and wait. So let's see what is the status? How are things looking for Karen? Card came out. Yeah, sorry, it was me shuffling. I know that sounds bad. This card came out. Let me take this down. On X, they're saying verdict. Let me check something here a second. Mark Betterow is on with, and I can't stream. I would stream Melanie, but I don't have her permission. So I'm just going to keep going back and forth. But here we go, my darlings, and I'm going to remove this just for a minute. I can put it back up when we see something. Look at this. This is how it's going. This is the jury wondering where to put things. That's what this is. And I think we saw this yesterday. Knowing where to put things, where to put particular things going on in this particular case. Did you, Annie, get the same? Yeah, sometimes there's too much going on in these, and I have to just step back a second. Okay, I'm shuffling. I know that's, I hate that sound, actually. We are manifesting a not guilty, but give us an idea, please. Okay, here's what I'm going to do. I'm going to lay out a couple of cards here. Give me a second, and then you can see it. How's that? I'm going to just move some things around, and then you can see. Stop. Between cats and commentary today. Okay, here we are. I know it, Angel. You're going to have to stop. Looky what's here. My messy desk. Stop, sissy, or you're getting down. Tell you, there's some, I love these guys, but there's a moment where you just have to say, okay, there we go. Okay, I want the table. Here we are, my darlings. I think they're in. Are they in there? Let me see. No, fan's still going. The fan is still going. Turtle Boy says back in court, no one knows why. Okay. Stop, Angel. Stop. We'll kiss later. Get that card comes out. She does look beautiful and strong. Okay. From what I'm seeing here, let me move these over so you can see. The jury looks to be holding on pretty tightly. Of course, there has been, it looks like some jury members have lost some sleep as well. This has been hard, I think harder on the jury because, I mean, think about it. It is a huge, we have sound. Let me see. Give me a second. No. Okay. Court is in session. We have sound. Okay, hold on. Hold on. Oh, they want to go home. Okay. But of course, we didn't see that because it's on Melanie's channel because the jokesters from Court TV is not streaming that. Let me get another channel. Boston 25 doesn't have it either. Court TV. Am I behind? No, I can't be behind. So it looks like they want to go home. They left. Okay. Hold on, somebody's coming in. I can hear them talking. I know, I can't stream anybody else's. No other content creator. Okay, so it's on here. So let's just watch it here. Okay, let me get this queued up so everybody can hear it. Because court TV is trash as usual. Okay, here we go. I'll start it here. Then we can watch it together. The clock will stop, my darlings. She'll be in a second. I backed it up so we can all watch it. Court TV is awful. We're not going to do them again. No, they didn't make a decision. They're going home. You know, it's a Friday afternoon. They want to go home. It's Father's Day weekend. Let me fix this.
If you happen to see, hear, or read anything about the case, please disregard it and let us know. Do not talk to anyone, and that includes each other. So when you walk out the deliberation door, you have to stop talking about this case. Even when you come into the courtroom, don't mutter anything to each other, certainly not on the ride or anything like that. So it's very important that you remember that. And you cannot, even if you get here before you're called into court on Monday, you can't discuss the case then. And that goes for the alternates as well. So we really appreciate that. Watch your social media use and the papers and the news. Stay away from all of that if you can this weekend. See you Monday morning, ready to start fresh.
Okay, that seems to be it.
All right, well, I hope everyone has a good weekend with no work.
Thank you.
Oh, forevermore. Okay, let me get rid of this. Stream. Let me get rid of that. Unshare everything. You know, don't you love that? Well, I hope everyone has a good weekend. I mean, Karen, you're facing prison for the rest of your life, but have a good weekend. All right, my darlings, let's get back to this. Where am I? Here we are. Let's get back to this. It shows what I was going to say is the jurors were concerned about this last night. And I think that there were some, and I think they're tired. I mean, think about this. They've been through a lot, sitting there listening to closing arguments today, I knew that would happen. They would get lunch, and then, you know, they always want to get the lunch. Hello. But who knows who they get lunch from. But I got to say this. They are wondering where to put things how to fill out this form is going to be on Monday. But it looks like a fresh start between the high priestess, this ace of swords, the fool card. They're going to hold on to their thoughts. They're going to hold on to everything. This fool card, nobody's the fool. But what this means is starting over, a fresh new start. And that's for Karen. But they also want a fresh start on Monday, because now they've seen all the evidence. Now they can talk about it on Monday. They just want to enjoy their weekend. And I'm going to say, I think it'll be Monday when they come back. This is a timing card. And it has everything to do with thoughts. It has everything to do with legal. It has everything to do with, you see, cut both ways. A sword cuts both ways. The sword can basically say, okay, this is, and it's upright. So they want to do the right thing. That's for sure. But I think they just want to rest. I mean, think about this. They've been through, it's been hard on us. But imagine being the jury. Imagine being the jury, my darlings, and knowing all of this information. I mean, they're going through a brain dump right now. This is almost like a debriefing period. They know what they're going to do. I'm going to tell you, I just think that it's good. I just think it's good. I think they're tired. Yes, they probably do want to. They probably do. Thank you, Patty. They probably do want to pray on things. I would want to. I mean, think about it. Maybe they all agree, but when I want to rest and come, I'm with you, Melina. Oh, how pretty. Look how pretty she is, everybody. Hello. I think you all are beautiful. Hi, hippie chick. I love you. The jury couldn't turn off Hank, right? Let's lay out a few more cards. Let's pull out a few more cards. I'm sorry I've got a few little spots on my table. But here we are. It's good. The energy is good. We will do some EVPs tonight. Quite frankly, I am tired too. I've been up since the crack. I got up this morning and I'm thinking, my heck, I didn't know 4 o'clock came twice in one day. There we go. Here we are. But, I'm going to tell you, Karen probably wanted this too, because she's probably thinking, look, I want to spend Father's Day with my dad. What if something, I would be that way. What if something happened? What if I came back? What if something happened and I would not get to hug my dad again? Think about it. It's a lot of time to digest. I did not think they would come back today. But Monday, I think we may get something. There you go, Bob. Boda Bob says, my old wall clock is correct twice a day. Let's see. I want to ask about Monday. Let's ask about Monday. I've seen worse humanity coming from Norfolk County, but I've seen the best in mankind like this. That I saw that from Mr. Reed as well. See, right? I mean, she's going to want to spend, I know she's relieved, and I know she feels pretty good about it, but I mean, think about it. She's got all this hanging over her head. So here we are. What did I just say? She's got all this hanging over her head. Oh boy, this is a good one. Okay, my darlings. This is pretty amazing. This is on Monday, the jury looking at things from a different perspective. This is misbehaving in Florida. Thank you so much. I'm about to drive, so I won't be able to say bye when you're completely done. Well, bless you, my darling. You be safe and you have a good weekend. If you can come in tomorrow night, we'd love to have you. We're going to do some EVPs. We're going to do all that. Thank you. Thank you, Zinjin. Thank you. Okay. And I want to thank you. Somebody just said, please put your Venmo up. So there it is. Thank you, because somebody just sent me something. So thank you so much. I can't see it because I have to look on this particular camera. So thank you. Adventures Spirit 66. I love your channel and the way you read. Oh, look, I love your hat and your sunglasses. You look so vacation-y. Do I need a holiday? Oh, yeah. But it's okay. It's okay. Yeah, I'm going to wait for tomorrow to read Miss AD's email, and you're going to want to be here for that because her mama called me. Let me glance at this for a second. I just want to tell. Oh, I think I got rid of it. Her mama called me way back in the early days when I was on Psychic Friends Network. AD's mama called me. Now talk about a small world. And I did not get to see the, let me see here something. I've got to open that anyway. But let me, you know what? It's not too long. It's not too long. I'm going to read it, and I'll read it again tomorrow because I think it's important. This is from our beautiful mod AD, whose mother called me. Here is the email that she just sent me just a little while ago. A long time ago, my mother reached out to you through Psychic Line. It was Psychic Friends Network, seeking guidance and clarity during a profoundly difficult time in our lives that felt almost surmountable. She was struggling to cope with the tremendous loss of my brother, who tragically lost his life due to a drunk driver. Oh, I'm so sorry. I think I remember this. An event that shattered our family and left us grappling with grief and confusion. The weight of that sorrow was almost unbearable for her, and she often felt lost in her own emotions, unable to find a way to navigate through the overwhelming darkness that surrounded her heart. Wow, that very eloquently written. After speaking with you, after she spoke with me, she finally felt a sense of understanding and peace that eluded her for so long. It was as if a heavy fog had lifted, allowing her to see clarity for the first time. She realized that my brother needed to move on to the light, to find solace and freedom from the pain and struggles of this world. This epiphany brought her comfort and renewed sense of purpose, helping her to understand that holding on to his memory in a way that kept him tethered to her own sorrow would not honor him as he deserved. With that revelation, she was able to let him go, allowing herself to accept his passing and honor his memory in a healthier, more loving way. Now, while we experience a few dark days filled with sadness and longing for my brother's presence, the overall heaviness that once consumed us has lifted. We can cherish the beautiful moments we shared with him, reflecting on the joy he brought into our lives and the lessons he taught us. Though the ache of his absence remains, we find solace in the belief that he is at peace, and he is, my darling, and that gives us strength as we continue to navigate life without him. Love and light, AD. Isn't that is a beautiful thing? Beautiful, beautiful. Thank you so much for sending that. Oh boy, the storm sirens are going off. Yippee. All right. Let me finish this hand, and then we may just say goodnight. Oh, and it's 4:44 Eastern right now, my darlings. 4:44. And do me a favor, you members here in the chat, while I'm reading this, please add the emoji that says not guilty. It's got Karen's picture on it, says not guilty. So Thank you so much. That was just beautiful. And a big thanks to you, AD, for sharing that. I think I remember that. And I still have clients from back in the day. That was in the 80s and early 90s. It was beautifully written. And that what a beautiful little tidbit that I can take with me. Thank you so much. So it's funny because I'm talking about hanging around, and then we got the hanged man. Funny enough, right? So here's what they think. That's what the jury is going to be thinking on Monday. They're going to have the weekend, and I'm sorry to say this, but you're going to tell me that they're going to be with family and not sharing this? Maybe. I don't know. But they're going to be thinking about this. This is someone who is running away from responsibility, and it's not Karen. It's someone who is looking over their shoulder, trying to avoid being caught, and it's not Karen. The jury is going to be thinking about AJ. How do I know that? Well, because this is the moon card, the significator card for Pisces, and that is definitely, if you don't have that emoji, if you're not a member in the chat, my darlings, just do me a favor and put not guilty. Just do that. Just put not guilty in there. That will work. Oh, okay. All right. So anyway, this is the significator card for Pisces, the moon. Now look at this. This is technically, let's go through this card. These are to be the gates of heaven. The gates of heaven in this, what they're talking about is it's heaven when you reach a particular goal. They've had a long road to go. See this? Here we have depicted a doggy. Pretty ironic, right? A wolf. And this little crusty guy. And the significance of this little crusty guy means that even the one who is the less intelligent, sorry, buddy, can have a particular goal and know that they need to get to a particular place. And it doesn't matter if it's during day or night. It can be 24/7. So with this moon card, and of course it's a very empathic, and the one thing I've got to say about Karen, she's got that psychic gut instinct empathic going. So here's the thing. They're going to be talking about AJ and how he laid the foundation, how he constructed this. This is a card, this Five of Swords, again, swords, air, thoughts, and can be legal, are all about this winning. People laying down their swords. The ones that they felt got away with everything, laying down their swords and winning. Now, the one thing about I forgot to mention about the Hierophant, which is the 5th card in the tarot, that's a card that means overcoming trials. See, you can't make this stuff up. That card can literally mean overcoming trials. So that juror, which I don't feel this time that they're going to really try to spike this jury like they did the last time. I say spike it. But that's what I'm getting. But here's the great thing with these two. This, justice is blind sometimes. But you see that little dot, that little white dot above the blindfold on this person? And look at this person's eyes. Do you see that? It looks as though this person can see out from under the blindfold, like it's only about here. There's water, which is a life force, but of course, another air element, communications, thoughts, holding back the energy. And yet, remember, the swords go off the frame of the card, which means they're looking at the big picture. They are definitely looking at the big picture. I said within 24 hours of when they started deliberating, so it would not cover the weekend. So it would be, I'm going to say, I suspect Monday afternoon. It would be before noon on Tuesday at the very latest. But if we go past Wednesday, for anything other than questions, if we are waiting past Wednesday, I think we may be in a little trouble. And I think we may be headed to a mistrial, but I don't think so because of these cards. They're going to realize that these people are trying to get away literally with murder. Last but not least, this representation, not so much the Leo that this represents of that Leo season, but so much so of infinite amount of strength that Karen has. The jury will recognize this. The jury sees this. You see this kitty right here, his back is curved in a down position. Her back is curved in an out position. It is made that way because there has to be some give and take, but there also has to be a way for the pieces of the puzzle to fit together. She's got a wreath around her head, which is most likely a wreath of laurel, which is winning, victory. And with this infinite symbol up there, she figured out, and look at this, she figured out how to overcome the strength of this cat by using her noodle, by using her God-given brain. And so that's what this really means. They're going to be figuring out how Karen actually can overcome this because she didn't do it. And it's going to have to be somebody who comes in there and thinks their way through this, because on a normal level, you could not take on a lion like this and not overcome. Sometimes intelligence overcomes strength. Think about it. I love it. Thank you, AD, and thank you for sending that email, my darling. I appreciate you so much. This is wonderful. Let me see what time it is. Okay. So yeah, let's see what's on the bottom of the deck. Oh yeah, you're going to love this. The Judgment card. I call this the Discernment card. And see how her wings go off the frame of the deck of both sides? That is the divine covering. There is more of a divine, intense, divine presence. I'm loving it. I'm loving it. I like this. So Monday, I think we're going to see a lot more. The Judgment, it's like waking up. That's what this card is. Look. But you can see what these people are in. It's kind of a dark thing. But this is the wake up card. You're waking up and smelling the roses. You're looking at things from a different perspective. These two cards right here are really, really important in this little mess that I created. But this is telling, they're looking at things from a different perspective, and they're going to wake up to the truth. The truth will set her free. So there we go, my darlings. I'll tell you what, I am sort of kind of beat, and I need to take a break for a minute, clean my kitchen, do all those things that I wish I could just move my nose. Remember that? Move my nose and have it done. How do I read the star card? The star card not only is Aquarian energy, but it's a card that can mean yes. It is a card that can mean that your hopes and dreams and manifestation and wishes come true, but especially that your prayers and meditation have been heard. And that balance is required in order to move on and move forward. Yeah, I think we do meet it. I hope that helps, Amy. I hope that helps. What time are you starting on Monday? Probably as early as I can. Probably something like 10 minutes to 9, something like that. There we go. 10 minutes to 9. And we'll go. I mean, I may have to get up and walk around a minute. But there we go. But and then tomorrow night, our live will start at 7 p.m. And I'm going to take it easy tomorrow night. I'm going to try to do things that are not draining me energy-wise during this time. Because I am working the psychic line. I've got some other readings that I've got to do. And by the way, if you're wanting video readings, you can go back. We're starting that again. So there we are. All is well, my darlings. So I'm going to, I think, make some chicken enchiladas with some sour cream sauce and probably my little sugar-free cheesecake thing with some, I got frozen strawberries. I have to cheat on that. But I'm going to like distract. And I'm going to see you again tomorrow night, my darlings, and we'll be back and we'll be here refreshed. I may be in another room in the house. You just don't know. Be prepared. All is easy breezy. All is well, my darlings. Oh my God, a ham sandwich, right? Everybody enjoy your ham sandwiches. But thank you so much for being here. And thanks for entertaining me during this time. I appreciate you so much. Bless you. Bless the mods for being here. Can't wait to see all of you tomorrow night. Get some rest. We've got a hefty few days coming. And then, my darlings, we're back at it with everything else. We're going to talk about maybe even the Kohlberger case. I have some theories about that. There's some things there that don't make sense to me. I don't know. We're going to talk about as when this ends, Sandra Birchmore. We've got many other things. Dream Feed Media, our dear Grace, wants me to talk about some people, some 2 little children from Nova Scotia that seems to have just vanished. And then we're going to be talking about paranormal crime stories. And there are many. And there is a particular lawyer that I want to invite to come on over when this is over to tell us about his clients who had a haunted house and somebody was held legally responsible because they did not disclose it. How interesting, right? Oh boy. So anyway, my darlings, life goes on and we're here to live it. Thanks so much for being here. Enchiladas. I'll have to listen, I'm going to tell you how to make the best rice going. Throw away your instructions. The best rice going. 3 cups of water, and I use 2 teaspoons of the Knorr chicken bouillon. So 3 cups of water, 2 teaspoons of Knorr chicken bouillon, and 1 cup of rice. You saute the rice first. You don't rinse it. You saute the rice and you get it nice and toasty. Then you put the 3 cups of water, you put the lid on it, and you let it go until it's all absorbed. And when I'm making Mexican rice, I add a little bit of, can be all kinds of little things, Mexican corn, but I don't use tomato sauce. I use a little bit of ketchup. And it's delicious. So thank you so much for being here, my darlings. Hang tight for the end. I'll see you soon. I'm going to be getting a lot of kisses, I have a feeling. Love to each and every one of you. Thanks again for being here. And I'll see you tomorrow night. We're not in court, but I'll see you tomorrow night. Thanks again, my darlings. Bye for now. They'll tell you the facts are clear, but the truth always flickers between the lines. In every shadow, there's a secret that refuses to stay buried. Clues hide in symbols, and sometimes even fate won't show its hand. Voices echo not just from the living, but from the silence they leave behind. I'm Lady Zelda. This is Seeing Crime, where what's hidden doesn't stay hidden for long. Until next time, keep watching.